All right. If you're with me, I think you are, although you're a few seconds behind, so that's a little weird. So I'm going to cover up watching myself in reverse. Here we are. So this is the first live stream of my channel. So hopefully everything will be operating smoothly, which I doubt will be happening, but bear with me. One thing I'm going to load up here is I'm going to record this audio as well. So that's going. All right. Anyway, so today has been quite the day for this lawsuit. And I mean, I did not expect these documents to drop. I did not expect it at all because I was trying to... One, I've been trying to figure out this entire time why Kaufman had not responded yet to this lawsuit, because Kaufman is the only person who is actually served personally, and therefore his time to I do hope Maddox is in the chat room. I do hope Maddox is in there. Maddox, if you're watching, buddy, this is for you. And I dedicate this episode to you. I am going to have the most fun I can think of reading this document, obliterating you and your ridiculous counsel who has no idea what's going on. Yeah, I'll stop reading the chat log in a second. But first, I just have to get excited about the potential that Maddox will see this and yet again watch someone tear apart his stupidest investment that he may have ever made. Good job, buddy. So, anyway, as I was saying, I was not sure why Kaufman had not responded yet. And then I was looking over the document and I noticed that the service on Kaufman, on Weber Shandwick, and on Asterios was improper because the notary's certification and seal had expired 10 days before they signed the document. So I thought that Weber Shandwick, Kaufman, and Kaufman were going to completely ignore this. I thought maybe they caught that, and I didn't, because who would think a notary seal would be expired like that? It's just something that doesn't enter the, you'd figure that's such an obvious thing that the person getting the notary done would have caught it. But, they didn't. So I was actually kind of hoping this wouldn't drop because documents have been coming out left and right, and every day I'm doing another one of these videos. And while they are fun to do, they're tiring because they come out late and I have a family to deal with, which makes me do these things late at night. So, however, after that revelation and me just gloating over the continued incompetence of Maddox, and Landau presumably being incompetent as well, I've been trying not to pin a bunch of blame on Landau because maybe he's taken a really hands-off approach, but at this point, it's looking really bad. And again, Maddox, free advice from a former fan. This is not legal advice. This is life advice. Look into the people you have hired because either you are incompetent or they're incompetent. Most likely, it's either you or both of you. But anyway, oh my goodness. So then Weber, Shandwick, and Kaufman go ahead and drop this beautiful motion to dismiss. And I read the first page, and I thought, oh dear Lord, they're pissed, right? And they look furious. And they have come out swinging harder than any of the lawyers so far, at least from what I can tell from the first page. But I decided to stop and do a test run of this live stream thing, and see how this goes. And hopefully we'll be doing more live stuff coming up on Patreon for the Patreon subscribers. So you can look into that if you want. I thoroughly encourage you to do so because, your donations help me do this and make this even more fun. Anyway, so I'm going to start scrolling through this document. We're going to get going. And yeah, just, I guess let's just enjoy this. I am drinking, tonight, I am drinking Lagavulin 12, which is a personal favorite of mine. And it's merited in this case. So as before, again, just laying out that this is a well-drafted document. You can tell immediately because they have a very detailed and thorough table of contents that they're trying to make this document easy for everybody involved. So they've got table of contents, table of authorities. Again, something Maddox's lawyers... Now, complaints typically aren't written in this format. But again, I'm just pointing out that the formatting on their complaint was garbage, having the inline citations that are impossible to read, rather than having a nice set of appendices and exhibits that could be referenced by a reader when they're going back to read this thing. And that's something that I guess is a stylistic choice, but they made the wrong one. So let's get into this. Defendant CMGRP Incorporated, doing business as Weber Shandwick, and Joshua Kaufman respectfully submit this memorandum of law in support of their motion, pursuant to CPLR 3211A1 and 7, to dismiss the complaint filed by plaintiffs Maddox and Jane Doe as to those causes of actions asserted against Weber Shandwick and Kaufman based on documentary evidence and for failure to state a claim upon which relief can be granted. This motion seeks dismissal of the complaint's 9th, 10th, 11th, and 12th causes of action. The complaint's other causes of action are not asserted against Weber, Shandwick, and Kaufman, and therefore are not assessed herein. Preliminary statement. Hold on. Okay, sorry. This lawsuit is the latest shot in a long-standing and deeply personal fight between plaintiffs on one hand and several of the defendants on the other. Weber, Shandwick, and Kaufman have no involvement in that fight and no stake in its outcome, despite plaintiffs' flawed attempt to drag them into this lawsuit, which is itself born from a transparent attempt to embarrass Weber, Shandwick into terminating the employment of a defendant Asterios Kokonos, as explained in more detail below. The two warring groups are comprised of several internet personalities, each of whom creates content that is predominantly crass and sophomoric. So they must be fans of the show then, right? And then monetizes that content by distributing it through various social media platforms and other websites. They should put in brackets right here to degenerates, I guess, but that's fine. Apparently their internet content now includes personal attacks on each other, and each side has accused the other of harassment. I mean, sort of, but whatever, doesn't matter. The dispute underlying this lawsuit has spun off at least two legal actions in addition to the present lawsuit, neither of which involves Weber, Shandwick, or Kaufman. One member of the warring groups, Kokonos, happens to be employed by Weber Shandwick. Like it's just an accident, I guess. Sorry, Asterios. Which is one of the top PR agencies in the world with thousands of employees. In some, we barely know he exists, but we're very happy he does. In February 2017, an individual who identified herself only as Heather emailed several executives. Several executives. How pitiful are you to waste your day emailing executives about a copywriter, you flipping idiot? And copied persons she believed were Weber Shandwick's clients. Claiming to be a journalist writing a story on, quote, online trolls, bullying, and harassment on behalf of Condé Nast Media Group. This flipping idiot can't even spell spell the name of the fake organization she works for correctly. That email was forwarded to Kaufman, who serves as an in-house attorney and executive at Weber Shandwick. Heather's email and subsequent emails sought comment on an alleged misogynistic harassment campaign by Kokonos against unnamed persons. Heather's stated goal was to see if companies like Weber Shandwick would hold employees like Kokonos, quote, accountable for online statements. Kaufman requested more information before responding to Heather's questions, but the anonymous writer refused to provide any. Oh, and there's a footnote. That'll be fun. Based on the brief exchange, plaintiffs now seek to hold Weber Shandwick and Kaufman liable for various forms of negligence, alleging incredibly... incredibly that Weber Shandwick and Kaufman owed the plaintiffs a duty to somehow protect them from Kokonos' personal internet activity, which was not performed in the scope of his employment and did not involve Weber Shandwick in any way. Okay, real quick law down on this. They're setting up the obvious problem with Maddox's assertions that Kokonos did this on company time or whatever. That doesn't matter. To set up principal agency liability, not only do you have to be on company time, you have to be acting in the course of your work. Within the scope of your employment, as they lay out here. If you go off track from your employment, you lose that principal agency relationship. For example, if an Israeli soldier is acting in the line of duty, right, and he's out fighting someone from a country around them, one of their enemies, then he's acting as an agent of the state of Israel, right? If that soldier is ordered to go into a village and root out some sort of insurgency, but then he doesn't go into the village to root out the insurgency, he instead goes somewhere else and participates in some sort of other activity, like gets in a car accident, right? But he's going the opposite direction of his orders, then he's no longer acting as an agent of Israel, because at that point he has lost the scope of his duty. He has strayed away from that path. So in that instance, he is no longer acting in that scope. So that's kind of an analogy to this. Even if Kokonos is on time, on Weber Shandwick's time, using Weber Shandwick's equipment, if Weber Shandwick hasn't given him an assignment that involves the creation of this content, then he's not acting as an agent of Weber Shandwick, and you don't get to add principal liability to it. So that's what they're hinting at here. And it's in a way, it kind of throws Asterios under the bus. But it doesn't actually throw Asterios under the bus. It just severs his activity from their liability. This is where I love this. The complaint is riddled with legal deficiencies. They could have just stopped there, right? And fails to state any cognizable claim against Weber Shandwick or Kaufman. Because of the total lack of merit in any of the claims asserted against them, it is abundantly clear that Weber Shandwick and Kaufman were named in this lawsuit for some tactical purpose, perhaps to further pressure the intended target, Kokonos and his group of friends, perhaps to gain publicity, or perhaps to try to extract some settlement from Weber Shandwick to make the case go away. Whatever their tactical purpose, plaintiffs have no claims against Weber Shandwick and Kaufman as a matter of law, and the complaint should be dismissed as to those two defendants. Footnotes. We note that, quote, Heather's emails contain an outdated address for Condé Nast, misspell the address as 4 Tims Square, misspell Condé Nast as Condé Nast, and give a general Condé Nast phone number as Heather's phone number. Weber Shandwick is not aware of any articles regarding Kokonos in any Condé Nast publication or any other publisher, other than articles reporting on the present lawsuit. Man. Statement of facts. The pertinent allegations in the complaint are summarized below. Additionally, this motion is supported by the affirmation of Michael Munoz, dated January 10th, and the affirmation of Joshua Kaufman, dated January 10th, both of which are submitted herewith. The parties. Plaintiff George Uzunian is a writer. They should have added a sigh. An internet personality. According to the complaint, Azunian goes by the name Maddox in his various commercial endeavors. Plaintiff Jane Doe is Azunian's girlfriend. Quote, collectively, Azunian and Doe are referred to herein as plaintiffs. Presumably, Doe's actual name is withheld to protect her identity, but Doe is identified by her internet moniker in the complaint. Idiots. You can just, read between the lines on these things. Idiots is after complaint. And a simple internet search reveals Doe's true identity in a matter of seconds. We refer to her as Doe in this motion, despite the fact that Doe is herself an internet personality with multiple publicly available videos and other content. Footnote. Defendant Weber Shandwick is a leading global communications and engagement firm headquartered in New York City with offices located in 77 cities across 31 countries, employing over 3,600 professionals. Weber Shandwick is a wholly owned unit of the Interpublic Group of Companies Incorporated, a public company listed on the New York Stock Exchange. Before we get to this next sentence, let's tackle these footnotes. The facts alleged in the complaint are taken as true solely for the purposes of this motion and not to the extent that they are legal conclusions or are contradicted by the express language or terms of the documents relied upon in the complaint and or submitted with this motion. Copy of the complaint is attached as Exhibit A to the Munoz Affirmation. And then 3, to the extent that the use of Jane Doe's alias works to the prejudice of Weber Shandwick or Kaufman, they reserve their rights to challenge that designation. Let's see. Weber Shandwick is a leader in all key public relations practices and provides services in corporate issues and advocacy, advertising, market research, and visual communications. Defendant Kaufman is general counsel and senior vice president, business and legal affairs for Weber Shandwick. Defendant Asterios Kokonos, who is not a party to this motion, is employed by Weber Shandwick. The complaint names 7 other defendants. None of these defendants is alleged to have any connection with Weber Shandwick or Kaufman. Prior disputes between the parties having nothing to do with Weber Shandwick or Kaufman. It's funny because their motion doesn't need to do this, but they're just highlighting the lunacy of these prior disputes and them being included in it. It's so dismissive. Plaintiff Azunian formerly had a business relationship with defendant Dax Herrera. As described below, that relationship ended in 2016. This lawsuit is at least the 3rd legal action between Azunian and Doe, who is Azunian's girlfriend on the one hand and Herrera and his girlfriend on the other. Below is a summary of the break in relations between Azunian and Herrera and the resulting legal disputes based on the complaint's allegations and publicly available documents. The complaint does not allege that Weber Shandwick or Kaufman have any connection directly or indirectly to the following events. Initial collaboration between Plaintiff Azunian and Defendant Herrera. The complaint alleges that Plaintiff Azunian and Defendant Herrera created a podcast in 2014 named The Biggest Problem in the Universe, henceforth known as The Podcast. According to a website apparently maintained by Plaintiff Azunian, the podcast discussed topics such as other N-words, guys who need to get laid, outrage porn, transgendered MMA fighters, pedophiles, loud muffler douchebags, bad blowjobs, piss driblets, and cowardly perverts. Guys, this is filed in court in New York. Quick recap of the footnote. Kokonos, represented by his own counsel, has made a separate motion to dismiss the claims against him. The Biggest Problem in the Universe podcast ended on or about May 31st, 2016. Restraining order against Plaintiff Doe. Doe is currently the subject of a restraining order in Los Angeles, California, based on allegations that Doe threatened and harassed the girlfriend of defendant Herrera and ex-girlfriend of Azunian, Marie Valenzuela, who's a wonderful person, might I add. Just from the very brief interaction I had with her, she seems very nice. She's also gorgeous. Good job, Dick. The publicly available file shows that, similar to the plaintiff's actions in this case, described in more detail below, Doe or someone on her behalf threatened to contact the school where Valenzuela is employed as a teacher and make baseless allegations against her. Doe followed through on her threat on or about May 4th, 2017. Specifically, Doe called Valenzuela's employer and said that Herrera and Valenzuela had been stalking the plaintiffs for the past 2 years and releasing private information on Herrera's public podcast. Doe further said that she called because she went online and saw there is a charter code of conduct form that staff and charter schools need to follow and the steps on how to place a complaint. After reviewing the information, the Superior Court of California issued a restraining order against Doe and in favor of Valenzuela on June 6, 2017, which remains in place until June 6, 2020. And hopefully it gets renewed at that point indefinitely, so that it's just a problem for the stupid idiots their entire lives. God, that'd be great. Trademark dispute between Uzunian and Herrera. According to publicly filed documents... real quick. We have redacted Doe's name and address in the exhibit submitted with the Munoz affidavit, although, again, preservation of her anonymity seems futile in light of her public persona. The allegations in the complaint describing Doe and information easily available on the internet. According to the publicly filed documents in January 2017, Plaintiff Uzunian filed an application in the U.S. Patent Trademark Office to register the biggest problem in the universe as a trademark. In June 2017, defendant Herrera filed an opposition to that registration, accusing Uzunian of falsely claiming ownership of the trademark, among other things. To say the least, right? Thus, litigation between Uzunian and Herrera has been ongoing for the last several months, well before filing of the complaint in this present lawsuit. And gee, do you think maybe that he filed the lawsuit in contemplation of the pending trademark action because he thought, like a dumb idiot, that he could file a lawsuit, make a bunch of baseless allegations, and then use that in court? I mean, maybe he did that. Just maybe someone who has no idea how the legal world works would think that way. Just maybe. Plaintiffs filed the complaint and dragged Weber Shandwick and Kaufman into their ongoing personal dispute with Herrera. Following those legal actions, plaintiffs filed the present complaint in November 2017. For its part, the complaint characterizes the aftermath of the break in relations between Uzunian and Herrera as a one-sided campaign of harassment by Herrera and other defendants, but notably not Weber Shandwick or Kaufman, against the plaintiffs. A brief aside. If you haven't ever had Lagavulin 12, I recommend you have it. The 16 is good. It is smooth. It is smoky. It's like eating a campfire and breathing out just a wondrous pile of smoke, right? It's good, and it warms the soul. The 12 is about 25% more alcohol in it. And it's like the first taste, only with a bunch of motor oil thrown in, and it's just freaking fantastic. Okay, sorry. I can't recommend the 12 enough. I have to special order it because I live in a town of 4 people. But they will special order it for me, so. Anyway. The complaint alleges that subsequent to the podcast, Herrera and, quote, the other individual defendants, sick, hammering on that apostrophe, created cyber mob attacks and numerous online harassment campaigns against the plaintiff, including threats of death and rape. The crux of the complaint relates to the alleged harassment by Herrera specifically through his podcast called The Dick Show and his website entitled Men Are Better Than Women. Yet the complaint consistently lumps several defendants together as engaging in, quote, online harassment campaigns against the plaintiffs without attributing any specific allegation to any specific defendant. And I would suggest not only to any specific defendant, but to any defendant, because it's constantly against the defendant's fans. It's constantly against the defendant's fans, not against the defendants individually. The complainant does not allege that either Weber Shandwick or Kaufman participated in the harassment campaign. Instead, the claims against Weber Shandwick and Kaufman arise from their alleged negligence with respect to Kokonos. Kokonos is a Weber Shandwick employee and allegedly is aligned with and supports Herrera in the harassment campaign against plaintiffs. Those allegations are addressed in more detail below. The complaint alleges that Weber Shandwick and Kaufman knew or should have known of Kokonos' allegedly wrongful actions sometime between February 22nd or 25th, 2017, when a person identified only as Heather sent emails to Weber Shandwick accusing Kokonos of participating in harassment against unnamed individuals. The complaint does not allege that Weber Shandwick or Kaufman knew or should have known of Kokonos' alleged activities prior to February 22nd, 2017, the date that Heather first emailed Weber Shandwick regarding Kokonos. To the contrary, The complaint alleges that Weber, Shandwick, and Kaufman knew or should have known of defendant Kokonos' propensity for conduct which caused injury to plaintiffs. Sick. Because of the information they received from Heather on February 22nd. Because that's what we're supposed to do, right? We're supposed to take the words of anonymous internet people with Gmail accounts that can be made on the spot for free. We're supposed to take that over our experience with the person, over with applicable law, over with employment contract problems, and we're supposed to just fire them outright because some anonymous internet dummy decided to send us an email and to send frantic emails to several executives like a flipping moron. Alleged harassment occurring prior to notice to Weber, Shandwick, and Kaufman of Kokonos' alleged conduct. Lots of allegeds, right? Because they're careful. You know, like part of their defense. Yes, I know the baby's crying, but my wife is out there and she is very gracious to allow me to do this early and take control of getting 5 kids to sleep at bedtime. So we all owe her a wonderful debt of gratitude. And hopefully, you know, she, I don't know if she's watching this, but that'd be funny. You know, I'm very thankful for her to allowing me to push this up 2 hours so more people could see it. Yeah. Anyway. Okay. Sorry for that. The complaint is replete with allegations that harassment and other egregious conduct occurred well before the date that Weber, Shandwick, or Kaufman allegedly should have known of Kokonos' online activities. Although many of the allegations do not specifically name Kokonos as a perpetrator. Oh, what was I saying? I was saying that they're kind of throwing Kokonos under the bus. But again, they're mainly just severing their argument. And I think it's very commendable how they've worded this, because what they could do is they could actually throw Asterios under the bus and say that they have nothing to do with his, defamatory activity. But they're pretty careful so far to make sure that everything is alleged and that, they don't actually support a factual allegation against him in any sort of way. And that's admirable. We would all be lucky to have an employer that would actually stand behind us in this way, when an obvious defense for Weber, Shandwick, and Kaufman would just be to say whatever illegal activities Asterios does are his own business. But they're not doing that right now. They may later. Like I said, I haven't read this document. This is all new to me. Although many of the allegations do not specifically name Kokonos as a perpetrator, he is generally lumped in with other defendants, and the complaint seeks to attribute liability to him as part of the defendant group. For example, the complaint cites a series of internet posts that were made between November 6th and 8th, 2016, and a podcast dated January 17, 2017, in support of its allegation that defendants, sick, I mean, when you screw up apostrophes or spelling or grammar so badly that every quote from your stupid complaint has a correction in it. And in this one, I just noticed this one has 2. Sorry. And their followers use Jane Doe's quote, sick pictures and allege that she had a sexually transmitted diseases. The complaint further cites a Facebook post by Herrera dated January 6th in alleging that Herrera and other defendants, including presumably Kokonos, willfully and maliciously encourages fans to contact plaintiff sponsors on his podcast and, quote, spammed one sponsor's, quote, social media sites with defamatory and outrageous accusations against plaintiff. Footnote. Munoz Exhibits E and F are printed versions of web pages cited in paragraph 103 of the complaint. The last page of Exhibit E sets forth the date, January 2017. When viewed online, the date appears near the top left of the web page, just under the title of the podcast, episode 33, Dick on Shaved Ice. So I haven't looked, but I'm guessing that that date doesn't show up on the submission. So they're just clarifying where they got that date. Outrageous accusations against Plaintiff Union. And states that as a result, the sponsor, quote, canceled plaintiff sponsorship on January 9th, 2017. The complaint cites an internet post dated January 7th, 2017, in alleging the, quote, misappropriation of plaintiff Jane Doe's image and her likeness for Herrera's own financial and perverse gain. As a final example, and again, like just reminding everybody that Dick didn't actually post that. He was replying to a tweet that posted that. As a final example, the complaint alleges that on January 16th, 18th, and 26th, 2017, Uzunian informed defendant Patreon Inc. about Herrera's harassment and stalking. I think they left out about 30 dates when Maddox was obsessively emailing them like a jilted girlfriend. Informed defendant Patreon Inc. about Herrera's harassment and stalking, including that Herrera's fans created a, quote, rape list and that Herrera had attacked Doe and disclosed Uzunian's, quote, private finances and his family's mental issues. Which is funny because, like, if I just say that, I think Maddox's parents have a gambling problem, that's an opinion. But if Maddox says that Dick is addressing Maddox's family's mental issues, like he's making it into a factual statement and basically agreeing that they have them. Good job, denigrating your own family, Maddox. I mean, that's not a surprise. You do it all the time. But great job creating that argument for yourself. Each of these examples illustrate harassment that allegedly occurred before February 22nd, the date on which complaint alleges that Weber, Shandwick, and Kaufman were on notice of harassment by Kokonos, Weber Shandwick's employee, and the complaint does not allege that Weber, Shandwick, or Kaufman knew or should have known of these actions when they occurred. In addition to the examples above, the complaint alleges that Kokonos made despicable podcast reportings at Weber Shandwick's office during work hours and used Weber Shandwick's, quote, equipment, technology, and studios for such recordings. The only such recording named in the complaint is a comedy album entitled Santa Cuck. Can you imagine the judge? Can you imagine the judge having to sit and read, like, Santa Cuck? I hope he looks it up. Like, let's hope for Asterios' sake that he gets a download out of it. Because that'd be even funnier if the flipping judge listened to Santa Cuck to, like, contemplate what was going on. Oh, dear God. And that reminds me of an old Supreme Court story. Just briefly digressing here. When the Supreme Court was first taking on the issue of obscenity in regards to pornography, there's a story that runs around at least some circles of constitutional law professors where during the trial, these justices, mind you, the average age of Supreme Court justices is something like 68 to 71. These justices are trying to figure out whether this particular item is a piece of obscenity or not within the convoluted meaning for obscenity that they have. So if you can imagine, the 9 geriatric justices take their clerks who are probably like just graduated from law school or potentially, have clerked for a couple district courts and were presumably from very high profile law schools. That's how you get to, clerkship for the Supreme Court is to graduate, very high in your class from a very prestigious law school and have some sort of connection to get your application in front of these guys. So a bunch of Ivy Leaguers and a bunch of Supreme Court justices go in the back room and then watch porn, right? In probably the most awkward, stilted viewing of porn in recorded history to determine whether or not this is obscenity. So, if you can only imagine, like, the judge and his clerk going on iTunes, downloading Santa Cuck, and determining if this amounts to defamation, that, to me, is just gold. And I hope it happens. We'll probably never know, but we can imagine that it probably does, right? Because, like, this is amusing. And if, judges deal with garbage every day. Judges and clerks go through tons of cases all the time that are always boring. And this one is so ridiculous as to be funny. and has so many high-profile defendants. Like Weber Shandwick has sent their counsel into court to defend against Santa Cuck. Like, God, I wish I could be in the judges' chambers when they listen to the album. Anyway, sorry for the digression, but we're gonna get back to it. I can't help looking at the word cuck in a legal document and taking it seriously. Santa Cuck allegedly contains, quote, harassment and vitriol towards plaintiffs sick. Every quote has a bad apostrophe in it. And the physical copies of the album allegedly included a phone number purporting to be Jane Doe's phone number. Remember, that's 867-5309. Because apparently plaintiffs have never heard of Tommy Two-Tone and one of the most iconic pop songs of the 1980s. However, documentary evidence establishes that Santa Cuck was released on iTunes on February 21st. So Weber Shandwick could have nothing to do with it. That's the best part. Therefore, even assuming that Kokonos used Weber Shandwick equipment to record Santa Cuck, and Weber Shandwick does not concede that he did. This is even funnier, because apparently Weber Shandwick is unwilling to admit, though they could actually state that Asterios used their equipment without their permission, and therefore they were investigating him. Instead, they go ahead and say, we don't concede that he actually did this. This allegation is maybe baseless. The recording occurred prior to the time at which the complaint alleged that Weber Shandwick or Kaufman should have known of Kokonos' activities. You stupid man, and your stupid lawsuit failed on just a basic fact. I mean, you failed in so many other places. I shouldn't be surprised anymore, but I can't help it. Your stupidity knows no bounds. None, and it's constantly surprising. Alleged notice to Weber, and it's alleged notice because they don't have notice. They have an anonymous email on the internet stating some things that they have never been able to verify. The complaint, I'm guessing, maybe they have verified them. We'll see. The complaint alleges that Weber, Shandwick, and Kaufman were notified of Kokonos' harassment of plaintiffs on or about February 22nd. On that date, an individual giving her name as Heather emailed Weber Shandwick stating that Kokonos, quote, is taking part in an online harassment and bullying campaign targeting individuals. Does this campaign have a manager? Like, does it have an organizational structure? What is an online campaign? Like, when we're going to use the word campaign, what does that actually mean? And seeking comment. The email and subsequent email... Briefly, and I apologize for digressing again, but when you're saying campaign, like when you're drafting a complaint, when you're drafting a legal document, every single word that you use has the potential to sink your case. So like if you allege that it's an online campaign, and then their activities don't amount to what the court would consider a campaign, and I don't know, I haven't researched this, but maybe New York has a standard for what a campaign consists of, and if you can factually dispute that it's a campaign, then you obviously didn't do it. That's the dumbest thing. Why on earth would you state it's a campaign other than having no idea what you're doing? And seeking comment. The email and subsequent emails were sent from a Gmail address. That's good. Just give me a minute. What I'm going to do now is switch drinks from scotch, which is a nice refined sipping drink. I'm going to switch to whiskey. I've had this in a couple other videos. This is the wheat whiskey. It's just under 50% alcohol. It's got a lot of kick to it. It's a little harsh in the best ways. I like it. It's got a sweet finish. It's from the 45th Parallel Distillery in Wisconsin. Got it from a charity auction, for a camp that helps out kids. It's the One Heartland camp in Minnesota, and I'm going to plug them in this video, which, I'm guessing they would probably not want. But they're a good organization, and the people who run it are good people. So if you have a mind towards philanthropy, look to One Heartland, look to Make-A-Wish. If you're in Minnesota, look to the Minnesota Zoo. Those are all charities that I support personally, and they're all run by good people who I've met. And they all on their auctions have scotch and whiskey. And what auction is complete without scotch and whiskey, right? The email and subsequent emails were sent from a Gmail address. And it's fun when you're reading these documents because they can look a little dry. But again, especially with something like this, they have inside counsel Kaufman. They have outside counsel, I think, Munoz, writing this document. These guys, Kaufman's an executive at Weber Shandwick. Like they said, a preeminent public relations firm based in New York City. Kaufman gets paid a ton of money. Their outside counsel probably gets paid more per hour than Kaufman does. So it's fun to read this and think that the person who is writing this, like, add the emphasis yourself because you know it's there. It's natural. These guys are actually probably very good writers. That they're into, they're in, this sort of profession of ours where we don't get a lot of artistic license, but you can infer it and know that this guy, the email and subsequent emails were sent from a Gmail address. Right? Like, just add that for yourself. Add that little glance, that ridiculous eye roll, because they know this is so stupid. And the fact that they're being paid to do this is just dessert. They're getting paid tons of money. This is a 29-page document, okay? Figure a half hour a page, okay? Like, figure a half hour a page of billable hours. Assume that these guys are getting paid $600 an hour. I mean, they got paid several $1,000s to write this document. And they're having a blast because this is so bad, and they get to unload, and they don't always get to do this. A lot, if you're going against a competent attorney, it's this dry exchange back and forth, or maybe there's some flair to it. But when you're going against an obvious lightweight like Maddox, or I guess if Landau wrote it, Landau. But guys, and the reason I'm trying not to be harsh on Landau is because we don't have enough facts to actually assert that he's this incompetent. But if it's Maddox or if it's Landau, it doesn't matter. Either one, whoever drafted that complaint is flipping terrible at their job, terrible at the task at hand. If it's Maddox, it's obviously not his job. I don't think he could competently perform really any job. So just remember that these guys are getting the chance to basically be a professional football team against a junior high B squad. And they get to unload. So just know that every single line is laced with venom. They are just disdainful of this complaint, and it's great. And every action that has occurred. Anyway, again, and I'm going to digress here and there because I'm sublimely happy and reveling in this, and I hope you guys are joining me with that. Heather's emails and the allegations asserted in those emails, described more fully below, are strikingly similar to the communications from Doe a few months later to the employer of Herrera's girlfriend. Uh-oh. Maybe if you have a particular writing style, it's identifiable. Just maybe. Like, Maddox, you should know this. You write, and people can identify your writing, or at least they could, based on it used to be funny and no longer is. They could identify it by your voice. I mean, maybe if you'd gone to writing college, like me, right? Like, I was literature and creative writing major guys, voted up. If you had done that, you'd know about voice. And maybe you wouldn't have failed out because we're talking this is easy street. Like, that's partly why I did it. No judgment. No judgment on writing majors. I love you all. I know you're hoping to live the dream. But, Maddox failed out of college, and I can't emphasize how Maddox failed 3 times by his own admission out of college. Had he taken a writing course, he maybe would have passed. Maybe not. I don't know. It's hard to say. Writing professors are weird. But had he done that, he would have understood that writers have a voice, and therefore Jane Doe would have had a voice, and unless you consciously change it, things tend to look the same. Her allegations asserted in those emails are strikingly similar to the communications from Doe a few months later, the employer of Herrera's girlfriend, resulting in the California restraining order against Doe. This is an interesting way to incorporate that restraining order, by the way. It has suddenly become relevant to the point that Jane Doe was completely lying. And that lie about who she is, that lie about Heather, that Maddox, by the way, you could have just said Jane Doe sent an email under the pseudonym Heather out of fear of retribution. You flipping Armenian idiot. You stupid, stupid, stupid man. Lying to the court never, ever, ever turns out well. It doesn't. That's the rule. That's the rule because the other lawyer can see through the lies. Anyway, Heather claimed to be a journey, working on a story for misspelled Condé Nast Media Group regarding, quote, online trolls and bullying and harassment. Heather did not identify herself or identify the individuals that allegedly were targets of the harassment and bullying campaign. Oops. Heather did not claim to be a target. Oh no, they left out a B. Did not claim to, quote, be, or brackets B. I'm going to put it in there for him because this is so well done so far. A target of harassment herself. Quote, Heather stated that she was informed by a, quote, women's comedy group, because that exists. Okay, I'm going to get my misogyny on. The funniest thing ever published by a women's comedy group is calling themselves a comedy group. Right? So, there we go. Kokonos, quote, records some of his segments after hours at Weber Shandwick and works with a person named Dick Masterson, who runs a website called Men Are Better Than Women, and has written misogynistic statements. The email went on to include several links to Herrera's Twitter account, including statements made by Herrera, not Kokonos, and a tweet from Kokonos' personal Twitter account using a phrase, cuck, to an unknown individual on Twitter. Guys, these are people who are paid by a PR firm hundreds of thousands of dollars a year, and they're dropping cuck. Whew. Heather stated that her goal was to know whether companies like Weber Shandwick will hold employees like Kokonos, quote, accountable for online statements. Hold them accountable for what? Accountable in what way? In what way? No one even knew that he worked for Weber. I guess you could find out. But no one cared that Asterios worked for Weber Shandwick until now. Until Maddox. She twice asked whether Kokonos will be held, quote, accountable. Yes, we'll give him a stern talking to. On February 23rd, 2017, Kaufman responded to the initial email from Heather and requested her complete contact details to speak with her directly concerning her email. Right? As any reasonable person would do, when someone purporting to be a journalist contacts them, you'd want to know what publication you're talking to. Because any reasonable person would be from a PR firm. You're talking to people who do this for a flipping living, and you're acting like just like a 14-year-old online. I'm gonna troll Asterios. What are you thinking? These people spin stories for And they're some of the best in the world at it for anybody who's high profile. And you're going to go ahead and just like pretend to be someone as if they don't have contacts at every major publication. They're a PR firm. It's their job to get a contact out to any major publication anywhere. They can probably look if there's a single Heather on staff at any publication, because they can call the personnel or HR rep and say, hey, which one of your journalists is named Heather? I got a contact and I'm looking to talk to her. And when they say, we don't have a Heather, or they say, we have Heather so-and-so, they can just call that person. They'll be like, I never sent you an email. This is a PR firm. That's like trying to hack the NSA, you idiot. God, you're so incompetent at everything. At everything. She, on February 23rd, 2017, Kaufman... Oh, sorry. I'm going back in time. Heather requested a statement on February 25th from Weber Shandwick, and 2 days later, Kaufman replied, again requesting her contact information, as Weber Shandwick needed to verify the identity of any reporter before making a statement on the record. Duh. They're a PR firm. They're not amateurs. You are. In response, Heather did not provide further contact details or information regarding the individuals allegedly subject to Kokkinos' harassment, but instead asked Kaufman to identify companies who work with Kokkinos in order to reach out to them directly about Kokkinos. Yeah, because what Weber Shandwick wants, what they want, is a reporter reaching out to their clients about the alleged misconduct of one of their copywriters. Think logically. For 1/8 of a second. I know you've never done it in your stupid life. Think logically for a second about what you're asking them to do. Go ahead and give me the name of one of your big clients that Asterios has worked for, because what I want to do is go tell them that one of your employees is a misogynist, racist, horrific person. That seems like something they'll do. Good job. In response, Heather did not provide further contact details or information regarding the individuals allegedly subject to harassment. Sorry, I just read that. She further stated that if Kaufman was unwilling to give a statement, quote, because of the relative anonymity of the piece, that is understandable, and she is not just a journalist, but an activist. Immediately, by the way, let me give free public relations advice to anyone listening. If someone contacts you and says that they're an activist, immediately stop contact. Immediately. Don't ever talk to them. Has an activist ever contacted you for a good thing? No. And obviously Weber Shandwick knows this. Heather then includes articles from Herrera's website concerning statements, again, made by Herrera, not Kokkinos, regarding rape. And, I don't know what the statements actually are. I don't even know if they were regarding rape or if they were made by Herrera. They might have been made by Herrera's fans. Doesn't matter. Again, this motion, the allegations from Weber Shandwick's motion can't be really used against Herrera in any sort of way. So, sorry, Clay, I'll drink more. Heather then includes, plaintiffs allege that Heather's anonymous and error-ridden communications. And there's a footnote. Oh, I can't wait. Put Weber Shandwick and Kaufman on notice of Kokkinos' allegedly unlawful conduct towards the plaintiffs. Footnote 7. Cuck. They define cuck in the footnote. Guys, can it get better? Cuck is an insult frequently used on the internet where it has, quote, become shorthand for any perceived weakness or rather perceived reluctance to exploit strength. And they're linked to a GQ article. And they probably know the guy who wrote it. He's probably a client or a source. Again, we note that, quote, Heather's emails contain an outdated address for Condé Nast. Misspelled that address as Fortin Square and misspelled Condé Nast as Condé Nast. Like they left off the accent aigu, right? If you're French, that's the upward accent in French is accent aigu. I assume Condé Nast is French. Maybe it's Spanish, and I don't know what that accent is called. So sue me, my expertise only goes so far. Oh my god. Oh my god. Koken knows alleged conduct after February 22nd. Plaintiffs claim that... Plaintiffs claim that after receiving notice on or about February 22nd, Weber, Shandwick, and Kaufman had a, quote, duty to investigate, but did, quote, nothing. Yet, contrary to that allegation, the complaint also alleges that Weber, Shandwick, and Kaufman took action in response to Heather's emails. Hello, you flipping idiots. They did nothing, but then they did stuff. Because it alleges that defendants somehow breached a duty of plaintiffs by investigating and telling Kokonos about Heather's complaints. Oh my goodness. And allegedly disclosing plaintiffs' identities. Plaintiffs' claims are remarkable because the emails attributed to Heather in complaint never identified Heather or the other individuals subject to the alleged harassment. The complaint alleges that in retaliation for Heather's complaint, more whiskey is required. Kokonos continued to harass plaintiffs after February 22nd, 2017 and made, quote, everything worse for the plaintiffs. Oh no. That's a legal standard, by the way. If you make everything worse, you're more liable. Yet, the only allegations after the so-called notice cannot be categorized as harassment by Kokonos. Here, Weber Shandwick even defends Asterios. And again, it's in their best interest to distance themselves from him in every way possible. It's in their best interest to do so. But they stick up for him, which is absolutely admirable. There is no factual allegation showing how Kokonos' knowledge of the complaints made, quote, everything much worse. And there is no factual allegation showing that Kokonos' post-February 22nd conduct involved Weber, Shandwick, or Kaufman. The allegations relating to Kokonos after February 22nd, 2017 include the following. Kokonos posted the following on Reddit. Quote, Maddox could, of course, also apologize. People at Madcast Media have contacted one of my employers 3 different times now, trying to get me in trouble for my affiliation with a comedy show. He can apologize for that. And if you don't know, Madcast Media has a habit of trying to impact people's personal and professional lives based on, the internet. They do. And not just the fans of Madcast Media, by the way, like actual people on Madcast Media. We know that Maddox has done it. I'm guessing you can figure out other people who have done it. And they do so based on stupidity over and over again and a misunderstanding of basic concepts. Because, frankly, they're just stupid. And they don't know anything. And the funniest part is the actual harassment campaigns against anybody are actually being perpetrated by people on Madcast Media. And if you don't know about Joel Chaco, right? Someone on Madcast Media went after him. They went after his mom. They went after his freelance work. They doxed him on their channel. And that's actual harassment, potentially actually in violation of laws. That's actual legal actionable actions. But Maddox employs these people and then comes out and accuses Dick, who hasn't participated in this in any way. He accuses Asterios and Madcucks and everybody else under the flipping sun who haven't done anything while participating in it at the highest levels of Madcast Media, which I assume is just Maddox. And any other potential co-hosts. I don't know if Rucka's done anything, but maybe, based on everything else. Anyway, 2 Reddit posts by Kokonos where he discusses writing a book out of, quote, spite and releasing it the same day as a book released by Maddox. There's no allegation that Kokonos ever wrote such book. Well, I mean, that's a problem, isn't it? Kind of like your mysterious disappearing billboard. Kokonos allegedly created an advertising campaign against Maddox on Reddit to misrepresent plaintiff's brand, Madcast fan statement. The complaint alleges that this was reported to Reddit and found in violation of its terms. We don't actually know if that's what happened. because the complaint alleges it, but they don't actually support it with evidence. Plaintiffs claim Kokkinos, in concert with Herrera, continued to, quote, create and incite sexual harassment and racist campaigns against Doe, although the only factual support for the allegation is a screenshot of threats from 6 people, none of whom are Kokkinos. In brackets, none of whom are Dick, none of whom are Maddox, none of whom are any defendant's name in the case. The complaint speculates, without any factual basis, that Kokkinos, quote, participated, created, and incited the so-called harassment campaigns during work hours from Weber Shandwick's offices, using Weber Shandwick's equipment and billing Weber Shandwick's clients for any time spent on such communications. This is a disastrous allegation. I haven't read on yet, and but I will say, like, this is a disgusting allegation because it seeks to smear Weber Shandwick. Because if Asterios is billing Weber Shandwick's clients for work activity, and then you go on to say that Weber Shandwick did nothing when being revealed, or when being enlightened to this information in a public document, you're basically telling that Weber Shandwick has defrauded its customers. You're accusing them of fraud without evidence, and that is not a good thing to do. Moreover, these allegations are contradicted by another allegation contained in the complaint. Oops! Drafting errors. Drafting errors are rife in this thing. I haven't even caught them all. Again, I missed the fact that their flipping notary stamp was expired. Oh my gosh, how many of them are there? It would take decades to find all of the stupidity in this. Emails from Heather to Kaufman stated that Kokkinos made inappropriate recordings, quote, after hours at Weber Shandwick. Oops. Oh my gosh. Argument. Under CPLR 32... So... We're just now getting to the argument. Like, they've just been stating facts and rules up until now. That's so funny. Oh my god. Under CPLR 3211A7, a party may move to dismiss one or more causes of action on the ground that the pleading fails to state a cause of action. We've seen this over and over. Maddox's lawsuit is a big pile of whining, and none of the facts are tangibly linked to any standard for a civil or criminal claim. Not one of them. And they could have probably done it. They could have done it poorly. But they could have at least tried. And they didn't. Because Maddox wrote this, because Maddox thinks lawyers aren't real. Just like economists. Just like every other expertise that he doesn't have. The court must be able to find, quote, from the pleadings 4 corners. This is a law term, so I'm going to just drop it in here. When you're talking about the 4 corners of a document, okay, that means that when you have, this is a contract term of art, okay? When you have 4 corners of a document, it means that everything is contained within the document itself. It's like a mental picture for you that there are 4 corners to this thing, that therefore you can't include other evidence. So when you're saying that the court must be able to find from the pleadings 4 corners factual allegations, that means that they can't later remedy their failure in the complaint, which taken together manifest, quote, a cause of action cognizable at law. Leibowitz versus Bank Lume Trust Company of New York, and Wiener versus Hirschman Leaker PC. And if you notice, there's a disturbing amount of Wiener citations going on in this case, in the trademark case. Look for those. That's a fun Easter egg if you're playing this as a video game or a drinking game. Quote, plaintiff's failure to allege facts that, if proven, would tend to establish each and every element of the claim as factual under 3211A7. Dismissal of claims pursuant to CPLR 3211A1, quote, is appropriate where the documentary evidence utterly refutes plaintiff's factual allegations, conclusively establishing a defense as a matter of law. This is when discovery documents that can be attributed to the plaintiff undermine their own argument. And that's a dumb thing because you're in control of what you disclose, you flipping idiots. I mean, you have a duty to disclose a bunch of things, but if people don't know certain things exist, and in this case, discovery hasn't really happened. I don't even know if initial disclosures have happened. If they have, we haven't seen them filed. But in this case, all of the disclosed documents are documents that they used thinking they were supporting their own arguments, being non-cognizant of the very arguments they were putting forward. That is the dumbest thing I can think of happening. Dismissal of claims pursuant to... I just read that. Sorry. The facts alleged in a pleading generally must be accepted as true and accorded the benefit of all reasonable inferences. However, quote, allegations consisting of bare legal conclusions, and they should have bracketed in bold just for fun, are not entitled to any such consideration. This is what I'm talking about with conclusory statements. You cannot use a statement of legal conclusion. You have to lead into that conclusion with facts. You have to use deductive reasoning, or at least inductive reasoning. You have to use reasoning. Reason is present in legal documents. When the claimant bases its claim on conclusory allegations and has failed to plead facts sufficient to support the elements of each of its claims, the motion to dismiss should be granted. Additionally, factual allegations that are neither inherently incredible or flatly contradictory by documentary evidence are not entitled to such consideration. Wow. All of the claims against Weber, Shandwick, and Kaufman must be dismissed for failure to allege negligence. Okay, so there's a standard for negligence, and it's across all forums. And if I'm wrong, correct me, but I don't think I am. But I'm drinking, and I'm having fun, so maybe I'll get this wording wrong. But the standard for negligence is this. Duty. You have to have duty. You have to have a duty to the other party. Breach. You have to breach that duty. Meaning, if you have a duty of disclosure, you have to not disclose. Or a fiduciary duty, you have to waste their money. Right? Okay. So you have to have duty. You have to have breach. You have to damage resulting from the breach. And then you have to have the court able to recompense for that damage resulting from the breach. Okay, you cannot just say that there's negligence. You have to show that they first had a duty, that they then breached that duty of care, that damage result from it, and that the court can fix that damage. And money doesn't fix everything, y'all. So you have to you have to remedy, or you have to allege all four things, and they have to be truthful. Each of the claims against Weber, Shandwick, and Kaufman allege some form of negligence. And if you notice in the complaint, that 4-part standard, which is in every single forum, because it's a common law standard, except maybe Louisiana, which uses a different type of law than the rest of the country, because they're all French and Cajun, and the French are weird. Every other forum uses the same standard for negligence. And New Orleans might too. I frankly don't know because I don't care. Or Louisiana. Sorry, Louisiana might too. I don't know because I don't study that type of law, because it's wholly different in a lot of ways. Okay. The 9th cause of action for negligent hiring and or retention. The 10th cause of action is for negligent supervision. The 11th cause of action is for negligence. 12th cause of action is for negligent infliction of emotional distress, which is one of the hardest claims you can possibly prove, but, go ahead. To state a claim arising from negligence, a complaint must generally allege... Oh, thank you. I can verify if I was right or wrong. They left out part 4. To state a claim, they must allege that the defendant owed a plaintiff a duty of reasonable care, the breach of that duty, and that such breach was the proximate cause of plaintiff's injuries. Okay, there's an ultimate cause or a but-for cause. I talked about this in a different video. The but-for cause, anything that causes something else is a but-for cause. But the proximate cause can actually supersede a but-for cause. Like, for example, if I spank my child, right, and then my child grows up to be a serial killer, you could say the but-for cause is that I spanked them. But there could be an intervening cause of mental illness or something like that along the way. That's the proximate cause. You driving a car and getting in an accident, you driving the car is a but-for cause, because if you weren't driving, the accident wouldn't have occurred. But you running the stop sign is what's called an intervening cause, and that's the proximate cause. You running the stop sign caused the accident, even though driving ultimately caused it. If you hadn't run the stop sign, it may not have occurred. Anyway, so that's what a proximate cause is in basic legal terms. I would attest that the fourth element is that the court can provide redress for these damages. Each of the claims against Weber, Shandwick, and Kaufman must be dismissed because the complainant does not adequately allege that Weber, Shandwick, or Kaufman 1. owed a duty, 2. acted without reasonable care, 3. proximately caused the alleged injuries. And they haven't even alleged injuries. They've alleged inferred injuries or presumed injuries. That's not the same thing. They haven't shown actual damages. Maddox has not shown how many books he didn't sell. We all know he didn't sell enough. From the start. Like, we know he didn't sell enough books because his book is ranked lower than Men Are Better Than Women, which has been out for a decade. That's just, or I guess 8 years, to be more accurate. That's just pathetic. But he didn't even allege that they've gone to therapy or hired private security. These are the type of damages you can assume you can show. You can show these damages and then tell the court why someone owes you $20 million or $400 million, depending on how you read it. The complaint does not adequately allege any duty owed to plaintiffs. The complaint does not allege any general duty owed to plaintiffs. The threshold question, quote, the threshold question in any negligence action is, does the defendant owe a legally recognized duty of care to plaintiff? Hamilton versus Beretta. That question is a legal question for the court. Here, the complaint does not allege any relationship between Weber, Shandwick, or Kaufman on the one hand and plaintiffs on the other. This is called privity, right? If you have a contract with someone, you have a relationship with them. If you don't have a contract with them, you have to then show why they owe you anything at all. Anything ever. And guys, to quote a disgusting Supreme Court case, Castle Rock, police don't even owe you a duty to enforce orders for protection. Okay? So that's how thin this standard is. You have to show, absent contract, why someone else owes you anything. Okay, they don't allege any relationship between Weber, Shandwick, or Kaufman and plaintiffs, let alone any relationship that would impose a duty of care to plaintiffs. According to the complaint, Weber, Shandwick, and Kaufman were never aware of plaintiffs' identities or any other details regarding plaintiffs. In fact, the complaint itself explicitly acknowledges that Weber, Shandwick, and Kaufman may not have an original duty to plaintiffs. Why would you defeat your own argument? Oh my goodness. Over and over they defeat their own argument. Despite the complete lack of these necessary allegations, the complaint alleges that Weber, Shandwick, and Kaufman had a duty to, quote, initiate an investigation against defendant Kokonos, B, quote, supervise Kokonos, and C, quote, keep plaintiff's identity sick. Private. Presumably from Kokonos. Wow. The complaint, therefore, asserts that Weber, Shandwick, and Kaufman owe a duty of care to police of private, non-work-related activities on the internet. That's emphasis added by Weber, Shandwick's attorneys. Of persons who happen to be Weber, Shandwick employees, and to conduct an investigation in a way that somehow does not alert those employees when an unknown member of the general public complains about that private non-work activity. Like if Weber Shandwick were to go ahead and fire Asterios in New York, which I don't know New York's employment law. I know Minnesota's. Minnesota's an at-will employment state. I don't think that New York is. So there may be a presumed contract, and if they go ahead and just fire someone based on out of work activity, they might be, opening themselves up to liability. You can't just do this. And Maddox lives in California, which is, I'm pretty sure, not an at-work state either, or an at-will state either. Not surprisingly, we have found no authority imposing such a duty of care on Weber Shandwick or Coffin. Instead, numerous courts have cautioned against imposing such amorphous, wide-reaching duties. The Court of Appeals considered a claim against an employer by the estate of a man who was killed by a drunk driver. Just before the fatal accident, the employer observed that its employee was intoxicated, fired the employee, and instructed him to leave the employer's premises. After the resulting accident, the decedent's estate sued the employer for negligence. The court examined the question of the employer's duty to the plaintiff and concluded that no such duty exists. The court wrote that to find otherwise, quote, would have broad ramifications, a factor we appropriately take into account in fixing the orbit of duty that would necessarily control other cases as well as this one. Where is the line to be drawn on the legal responsibility of an employer terminating an employee in these circumstances? What is the responsibility to third persons? What is the responsibility to such an employee who then goes out onto crime-ridden streets? What action would be required of employers to satisfy this legal duty? What action do they have a legal right to take? Like, what do you want them to do? Take his keys? They don't own his keys. Such vexing questions for which no reasonable solutions are suggested or indeed discernible persuade us that it would be unwise, on the facts presented here, to enlarge an employer's existing common law duties as plaintiffs suggest. Right? An employer cannot be responsible for what its employees do outside of the scope of the conduct that they're ordered to do. Because this should be obvious to any moron. Any moron. If an employee goes outside of the assigned task of the employer can't foresee that activity and therefore cannot be liable for the tort that follows. They have to be able to foresee the activity of the employee within the scope of employment and then foresee the damage that could result from that. That's where the duty shows up. The Court of Appeals has separately written that, quote, courts traditionally and as part of the common law process fix the duty point on balancing factors, including the reasonable expectations of parties in society generally, the proliferation of claims, likelihood of unlimited or insurer-like liability, disproportionate risk and reparations allocation, and public policies affecting the expansion or limitations of new channels of liability. Quote, affirming dismissal of claim by injured employee against contractor that installed a fan that injured plaintiff. I wonder if that's a funny case. Using these principles, the complaint does not allege a cognizable duty of care owed to plaintiffs. The duty that the complaint advocates is enormous. And it absolutely is. Defies reasonable expectations. Because the people alleging it aren't reasonable. They're not even real people. They're narcissist, histrionic personality disorder possessing LAites. And among people from Hollywood have narcissistic personality. Which is like judging a 10 based on a 10 on attractiveness based on a society of 9s. Jesus Christ. Using these principles, the complaint is not alleged a cognizable duty of care owed to plaintiffs. Oh, I just read this. Imposes extraordinary risk on employers and would lead to a proliferation of claims against employers whenever someone who happens to be an employee allegedly misbehaves on the internet. Allegedly misbehaves on the internet. And just a cursory view. Asterios, I love you, buddy, but you're super liberal. And in this case, I think that works to your credit. A person who goes out of his way to argue on behalf of protected classes and to block people who might denigrate those protective classes. Like, Asterios is overly cautious. He's actually probably the exact type of pseudo SJW that you want. And I mean that with all the love I can muster, because Asterios, despite everything, despite any drama that's happened behind us in the past. I think you're a funny guy, and I think you're a genuine guy. And I can't hold genuine things against anybody. And now I'm getting into like a slightly intoxicated, I love you, man, sort of phase. So I'm going to skip now and just read on. The alleged duty simply is outside any recognized legal bounds and therefore cannot be used to state claims against Weber Shandwick and Kaufman. The complaint does not allege not any assumed duty. The complaint explicitly acknowledges that Weber Shandwick and Kaufman may not have had an original duty to plaintiffs, but contained that Weber Shandwick and Kaufman voluntarily assumed a duty. You can't like accidentally assume a duty. You have to pretty much do it expressly or implicitly through your actions by, quote, undertaking to perform an act for the plaintiff's benefit. But I don't think they ever did that. The claim fails as a matter of law. The complainant does not allege any facts to support the legal conclusion that they voluntarily assumed a duty to plaintiffs. Like, the plaintiffs assumed that they would voluntarily assume that duty. They assumed an assumption, which is like a meta-assumption, even more pathetic. To establish a duty by voluntary assumption, the defendant must undertake to perform an act for the plaintiff's benefit, and that act must then be performed without due care for the safety of the plaintiff. See duty by voluntary undertaking, 14 New York practice. Like, okay, so these citations, and I'm pointing at something that I see and you don't, and I realize that. They're to secondary materials, research materials. They're not case law, right? These are books or treatises on New York's law of torts, generally written by a successful tort practitioner or a law professor or a team of lawyers. Okay, so a team of lawyers have written New York's Guide to Practicing on Torts and stated the standard of care based on a synthesis of several decisions. Quote, gratuitous conduct may give rise to liability only when defendant's affirmative action adversely affected the plaintiff and the defendant failed to act reasonably. Generally, voluntary duty cases arise where the defendant took affirmative action to, quote, help plaintiff, to provide medical aid or took physical control of the plaintiff, and in doing so negligently caused harm to plaintiff. Quote, defendant voluntarily guided plaintiff across crosswalk where plaintiff was hit by a car. Well, that's unfortunate. Quote, oh wait, sorry, I just read that. Yeah. Officers assumed duty where they physically removed intoxicated driver from car and left driver stranded on dark road within feet from railroad tracks. I bet that went well, right? Here the complaint does not allege that Weber Shandwick and or Kaufman took any affirmative actions emphasis for the benefit of plaintiffs. Rather, the allegations plainly show that the alleged actions were for the benefit of Weber Shandwick. According to the complaint, Kaufman assumed a duty to plaintiffs by, quote, answering plaintiffs' complaints, investigating Kokonos, and or informing him of plaintiffs' complaints. As an initial matter, the complaints made to Kaufman were lodged by, quote, Heather, who never identified herself or the alleged individual subject to the harassment in her emails. Rather, Heather claimed that Kokonos took part in online harassment campaigns, quote, targeting unnamed individuals. It is nonsensical to assert that Weber Shandwick or Kaufman took actions to benefit unnamed individuals about whom no details were provided in response to emails from another unknown individual who refused to identify herself. Seven pages, y'all. 7 pages. Second, Heather's emails to Kaufman show that she did not request that Weber Shandwick and or Kaufman assist plaintiffs or otherwise take any action for their benefit. And that's true. Heather asked whether Weber Shandwick or Kaufman were aware of the alleged harassment, whether Weber Shandwick condoned Kokonos' actions. At no time did Heather request help or assistance for herself or the alleged unidentified individuals. Oops. Neither did Kaufman promise help in his responses, which are quoted in the complaint. Kaufman's responses simply advise Heather that Weber Shandwick takes such allegations seriously and requests the identity and of and contact information for Heather in order to discuss the complaint with Heather. Such statements can in no way be construed as taking any action on behalf of plaintiffs or voluntarily assuming any duty to them. Third, even under the complaint's own allegations, Kaufman's subsequent investigation and disclosure of the complaints received by Heather were not actions performed for the benefit of plaintiffs. In her email, Heather claimed that Kokonos' records contain, that Kokonos records certain videos after hours at Weber Shandwick. The complaint alleges that in response to Heather's allegations that Kokonos used Weber Shandwick's office to record videos for personal use, Kaufman conducted an investigation and Kaufman told Kokonos of the complaints. Based on these allegations, Kaufman's investigation were clearly for the benefit of the company, Weber Shandwick, not the unidentified individuals allegedly mentioned in the anonymous email from Heather. There's simply no facts to support the claim that Kaufman undertook any investigation or conversation with Kokonos for the benefit of unknown individuals. Finally, this is a long section. Oh, I like whiskey, man. It hits you quick. And it doesn't last forever either. That's the other good part. Finally, the complaint alleges that Weber Shandwick Kaufman's response to Heather's email stands in the face of public representations made by the company regarding civility and trolling. But the cited, quote, public representations illustrate the fatal flaw in complaint's, quote, assumed duty claim. The article cited in the complaint discussed protecting companies from... You're talking to a public relations firm that would be hired by companies and high-profile individuals to manage their public image. They're not inherently not acting in defense of the public or any anonymous person. They're acting on behalf of their clients who are companies. You flipping idiot. Okay. Not individuals such as plaintiffs. For example, the report entitled Social Media's Role in Crisis Management cited by plaintiffs is not about protecting individuals from internet trolls, but rather advises companies on how to protect and safeguard companies against social media threats. Quote, discussing Weber Shandwick's software focus on preparing companies for social media attacks. The materials have nothing to do with protecting individuals such as plaintiffs or companies' alleged obligation to protect the public. Quote, concerning protection of the companies and its CEOs from risks associated with CEOs' social media engagement. Civility in America is a nationwide survey on Americans' views on civility. Plaintiffs also fail to state a claim for negligence based on assumed duty because plaintiffs do not allege detrimental reliance on Kaufman's alleged claim. In order for a party to be negligent in the performance of an assumed duty, the plaintiff must have known of and detrimentally relied on defendant's performance. Considering Heather is not the plaintiff's, right, George? Heather isn't you or Jess, right, George? You lying, stupid moron. She can't be acting... you can't have acted based on information she received, right, George? Because Heather is a real person, right? A finding that defendants voluntarily assumed a duty depends on, quote, whether defendant's conduct placed plaintiff in a more vulnerable position than plaintiff would have been had defendant done nothing. A plaintiff is placed in a, quote, worse position if, for instance, the defendant conduct either created or enhanced the risk of the plaintiff or induced the plaintiff to forego an opportunity to avoid risk. Here, plaintiffs summarily allege that Kaufman's, quote, actions or inactions made everything substantially worse for plaintiffs and effectively provided Kokonos with an unhindered ability to retaliate against plaintiffs' sick. Yet another flipping quote with another flipping correction. I think that's almost all of them. God. But the complaint does not allege any facts showing reliance or showing how plaintiffs were in a, quote, worse position by Kaufman's investigation or disclosure of the complaints. In fact, the complaint alleges that Kokonos knew the identities of the plaintiffs and had been, quote, harassing plaintiffs well before Heather wrote to Kaufman in February 2017. Right, if he knew their identities, then disclosing their identities isn't damaging. You dumb person. The complaint's specific allegations regarding Kokonos' post-February 22nd conduct do not support the conclusory statements that plaintiff's position significantly worsened because of alleged actions by Weber Shandwick or Kaufman. Therefore, the complaint's claim of an assumed duty fails as a matter of law. Holy Christ, that was a long section. But it was thorough and brutal and defeating. B, just in case that didn't work right, the complaint does not allege that Weber Shandwick or Kaufman acted without reasonable care. First, they failed to allege the first prong. Even if they did allege the first prong, they didn't allege the second. Even assuming, for argument's sake, because it's clearly not apparent from the facts, that Weber, Shandwick, and Kaufman owed a duty of care to plaintiffs, the complaint does not adequately allege that Shandwick or Kaufman acted without reasonable care in breach of that duty. Again, when you're drafting a lawsuit or a response or anything, lay out the standards for the offense and then show factually how they broke those standards. If you don't do that, you're going to fail 99 times out of 100. And if you don't do that against people who can afford attorneys, you're going to fail 100 times out of 100. The complaint alleges that following Heather's emails to Kaufman, which reported that Kokkinos was engaged in online harassment, quote, after hours against unidentified persons, Weber Shandwick, quote, notified defendant Kokkinos of the complaint and otherwise failed to adequately conduct an investigation in the matter. But it is absurd to assert that Weber, Shandwick, and Kaufman should have or even could have conducted some sort of investigation without speaking to Kokkinos. Who are they supposed to find out? If no one in the company knows he's doing this, who are they supposed to interview? You flipping stupid people. And the complaint asserts no allegations in support of its conclusion that Weber, Shandwick, and Kaufman conducted an inadequate investigation. In fact, the complaint's allegations strongly imply that Weber, Shandwick, and Kaufman did take adequate action. Prior to Heather's emails, the complaint alleges that Kokkinos and others threatened plaintiffs with death and rape, disrupted plaintiffs' corporate sponsorships, and disclosed private information about plaintiffs to their fans. Following Heather's emails and whatever actions Weber, Shandwick, and Kaufman allegedly took in response to those emails, the complaint alleges only that Kokkinos, 1, complained that his employer had been contacted, and 2, discussed writing a book out of spite and releasing it the same day as a book released by Uzunian, and 3, attempted to create an advertising campaign on social media platform against Uzunian. But the campaign was found to be in violation of the platform's terms of service. Thus, not only does the complaint utterly fail, story of your life, Maddox, you have utterly failed to properly monetize anything. You've utterly failed to expand your network. You've utterly failed to keep the biggest problem going because you're such a crybaby about something that was long ended. And you're such a narcissist that you can't admit when you're wrong. And you're such a non-expert that you're wrong all the time. You have utterly failed over and over, and you've done it again. Utterly failed to allege any specific ways in which Weber, Shandwick, or Kaufman acted unreasonably following Heather's emails, but the complaint further alleges that Kokkinos ceased threatening plaintiffs, counsel disrupting their corporate sponsorships, so they ceased counsel disrupting their corporate sponsorships. That's weirdly worded, or I'm just drinking too much. And ceased disseminating plaintiffs' private information about Weber, Shandwick, and Kaufman allegedly acted. Or after Weber, Shandwick, and Kaufman allegedly acted. All of this supports the opposite conclusion, that Weber, Shandwick, and Kaufman took some kind of adequate action with respect to Kokkinos. Well, that's embarrassing. Everything I said is actually exactly wrong. It's completely wrong in the exact opposite way, so that everything I said was actually, you just take the opposite and then everything is right. The complaint does not allege that Weber, Shandwick, or Kaufman caused plaintiffs' injuries. 3 pages, y'all. Bear with me. A necessary element of any negligence claim is that the defendant's alleged negligence caused the alleged injury. Right? Because I can be negligent and not hurt anybody, and that's fine. The complaint's own allegations, however, establish the absence of any such causation with respect to Weber, Shandwick, and Kaufman. First, the complaint alleges a long-standing campaign of harassment by several individuals, none of whom are alleged to have any connection with Weber, Shandwick, and Kaufman, other than Kokkinos. Indeed, the complaint does not allege any connection at all between the supposed ringleader of the harassment campaign, Herrera, and Weber, Shandwick, or Kaufman. And that's an interesting point, right? What if Asterios is just a fan wrapped up in the incitement by Dax? Therefore, the complaint itself establishes that even if Weber, Shandwick, and Kaufman negligently supervised Kokkinos or negligently investigated Heather's allegations against Kokkinos, plaintiff would have been subject to, quote, vitriolic harassment from Herrera and others, which means that the damage was caused absent the failure of duty of care. Second, the alleged harassment campaign allegedly... I'm losing track of how many alleged are in each sentence. Took place on publicly accessible internet platforms such as Facebook, Reddit, Amazon, Kiwi, and Patreon. The complaint does not allege that any action or inaction by Weber, Shandwick, or Kaufman made it possible for Kokkinos to utilize those platforms. Indeed, the complaint could not make any such allegation because they're public platforms that anybody can access. Notwithstanding any action or inaction by Weber, Shandwick, or Kaufman, Kokkinos would be able to access those platforms just as readily as the hundreds of millions of other people who access them through the internet every day. Every day. Although the complaint speculates that Kokkinos may have used Weber Shandwick's computers to access those platforms, he could just as easily have done through his own computer or phone, a friend's computer, or even a computer in a public library. The complaint does not allege otherwise. Because Kokkinos was able to use the internet for his alleged misdeeds, notwithstanding any action or inaction by Weber, Shandwick, or Kaufman, the complaint cannot allege that either of those defendants approximately caused plaintiff's injuries. Because, right, if Weber Shandwick simply blocked Asterios from any of these platforms, he'd just bring his phone or laptop and connect through a cellular network, for example, or an alternative public Wi-Fi, because you're in New York and they may have public Wi-Fi. I don't actually know. Don't live in New York. Don't care. The complaint does not adequately allege negligent hiring, retention, or supervision. Here, a competent attorney, as opposed to your attorney, has gone ahead and laid out the standard for this legal claim. To state claims for negligent hiring, retention, or supervision, a plaintiff must allege a quote, a duty owed by the defendant employer, a breach of that duty by defendant employer, and damages proximately caused by the defendant employer's breach. As a necessary element of this claim, a plaintiff must also properly allege that, quote, the employer knew or should have known of the employee's propensity for the conduct which caused the injury. As set forth above, the complaint fails to allege any cognizable duty of care owed by Weber, Shandwick, or Kaufman to plaintiffs, fails to allege that Weber, Shandwick, or Kaufman acted without reasonable care, and fails to allege that any action or inaction by them was a proximate cause of plaintiff's alleged injuries. For each of these reasons, 9th and 10th should be dismissed. Complaint does not allege action sufficient to sustain a claim for negligent infliction of emotional distress. 12th cause of action is for intentional infliction of emotional distress. Recovery for purely emotional damages is extremely limited. State a claim for negligent infliction of emotional distress. A complaint must allege A, an emotional injury, B, from defendant's breach of duty, C, which unreasonably endangered plaintiff's own physical safety, and again, B, that the court can fix, the court can remedy. That's important to any tort. The injury must be, quote, a direct rather than consequential result of defendant's alleged breach of its duty. It's got to be direct. It's got to be the direct result of the direct action. As stated above, the complaint fails to allege any cognizable duty of care owed by Weber, Shandwick, or Kaufman, and fails to allege that Weber, Shandwick, or Kaufman acted without reasonable care in breach of that duty. Even putting these defects aside, it is also the case that whatever injury plaintiff suffered would be a consequence, not a direct result, of the allegedly negligent actions or inactions by Weber, Shandwick, and Kaufman. Because the complaint does not allege any action by Weber, Shandwick, or Kaufman vis-a-vis plaintiffs. Don't drink and litigate, y'all. For each of these reasons, the complaint fails to state a claim for negligent infliction of emotional distress by Weber, Shandwick, or Kaufman. 12th cause of action should be dismissed. This cause of action, you just said it should be dismissed. Why do you have more? Seems rude, because I'm getting tired. This cause of action should be dismissed for the additional reason that the complaint... let me finish this whiskey. The complaint does not allege that Weber, Shandwick, or Kaufman's actions were, quote, so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community, which is required to state a claim for negligent infliction of emotional distress in the First Department. The complaint alleges that Weber, Shandwick, and Kaufman conducted a, quote, inadequate investigation. After receiving Heather's emails, the allegation fails to meet the required standard of outrageous extreme behavior outside the bounds of decency. The complaint further alleges that Weber, Shandwick, and Kaufman notified Kokonos of Heather's complaints. Again, this allegation does not describe outrageous, indecent, or extreme behavior. Because the complaint fails to allege actions sufficient in character to sustain a cause of action for negligent infliction of emotional distress, 12th cause of action must be dismissed. Claims against Weber, Shandwick, and Kaufman must be dismissed if the claims against Kokonos are dismissed. Ooh. Claims against Weber, Shandwick, and Kaufman must fail if the complaint's direct claims against Kokonos fail because the claims against Weber, Shandwick, and Kaufman arise from alleged negligence with respect to Kokonos' actions. So, even if their own argument fails, they still have Asterios' argument to fall back on. Therefore, to the extent applicable, Weber, Shandwick, and Kaufman incorporate as set forth herein any arguments made by Kokonos. And Kokonos' argument was good. It was good, man. In his own motion to dismiss the direct claims against him. So they get the benefit of Kokonos' argument. He unfortunately doesn't get the benefit of theirs. I mean, he gets a couple throw shout outs or whatever, credits. I don't even know. But they get the full benefit of his argument, and if he wins, they win. And they can also win without him. And they really should. Whether Kokonos is guilty or not, I think not. Because no one is guilty of anything other than making fun of a sad, formerly funny, washed up, balding, fat, boring Armenian who thinks himself smart, thinks himself a radio talk show personality, and thinks himself anything other than a jester. Anything other than a jester for our amusement. I lost the train of that sentence. You guys can figure it out. He is fat. He is fat, you liar. He's fat now. I'm saying he's fat. I don't care how unfat he may pretend to be. He's fat. Conclusion. For the foregoing reasons, the court should dismiss the complaint in its entirety and with prejudice against defendants Weber, Shandwick, and Kaufman, and grant Weber, Shandwick, and Kaufman such other and further relief as the court deems just and proper, including without limitation the costs and expenses they have incurred for responding to this action. Boom. That's it. That's this. So real quickly, the affirmations, which are pretty short, I'm going to go through them because I don't know what's in them. I didn't read them. So this is Munoz, an attorney duly admitted to practice in the state of New York, hereby affirms the following. I'm a member of the firm Golenbach, Eisman, Asor Bell, and Pesco LLP, attorneys for defendants CMGRP. This is their outside counsel. And mind you, if I'm assuming billion-dollar multinational corporation is hiring an attorney, I'm guessing they're good. I'm guessing they're better than the dog bite attorney based out of Michigan who happens to be licensed in New York and is still in grad school for his MBA. I respectfully submit this affirmation in support of motion filed simultaneously herewith on behalf of Weber, Shandwick, and Kaufman to dismiss the complaint filed by plaintiffs George and Jane Doe. Does anybody, if you want to throw Jane Doe's name in the chat, I'm feeling like going ahead and saying her actual name for whoever knows it. I would love to say it on air and just say over and over. I don't want to look it up because I'll look like a flipping idiot doing an internet search for it. So if someone else wants to find out what Jane Doe's name is, her real name, Jessica Blum. Jessica Blum. Thank you. Jessica Blum, Jessica Blum, Jessica Blum. I'm going to name her over and over. Jessica Blum, you're one of the stupidest people I've ever met. You're a cut rate model for trade shows that no one cares about. And you're dating like the least of a catch I can imagine. Someone who will probably be living in a dumpster in a couple days without your income, which is probably pitiful. Because, again, you're not a real model. You're a pretend model. Okay. We're going to call her Jessica Blum from now on. As to those causes of actions asserted against Weber, Shandwick, and Kaufman, based on documentary evidence and for failure to state a claim upon which relief can be granted. Attached hereto as Exhibit A is a true and correct copy of the complaint. B is true and correct copy of a website found at thebiggestproblemintheuniverse.com. Exhibit C is a copy of the firm from Superior Court obtained by my firm from the Superior Court of California in a case by Maria Elena Valenzuela against the individual Jessica Blum, who upon information and belief is Jessica Blum, identified as Jessica Blum in the complaint. Attached hereto as Exhibit D is a true and correct copy of the docket for an opposition to a trademark. By the way, check out my trademark, biggest trademark in the universe videos. They've gotten funnier. If you want a model, I'm gonna do a shout out to the chat. This is not mine. I can't take credit for this. If you want a model of a black piece of paper, Jessica Blum is the perfect model. That's funny, buddy. Yeah. Anyway, as I was saying, check out my trademark videos because they're really funny. And no, Clay, I can't drink at least 10 more times. Sorry. I've got to be able to walk to my bed in a couple minutes. Exhibit E is a true and correct copy of the website found, dickshow.com, episode 33. The last page sets forth the date that they mentioned in the earlier footnote, January 17th. Attached as Exhibit F is a true and correct copy of the website found at URL Kiwi Farms. Like, this is funny because Maddox raised all of these things in his deficient complaint. So now they get to post the Kiwi Farms website, which has nothing but negative information about Maddox. Maddox, you stupid moron. Why would you introduce something that only shows you to be an incompetent, vengeful, defamatory pile of garbage? Oh. Woo. When viewed online, the date that appears at the top left of the web page. Sorry. I'm reading that over and over again. I guess you guys will have to drink. A paralegal at my firm accessed the cited website and printed the attached exhibits. The attorney didn't bother going to Kiwi Farms. He sent a poor sap paralegal to do it. Oh my goodness. Like, I didn't even go there, guys. I sent my my paralegal to do it. F for the paralegal's dignity. Attached here to is Exhibit G is a true and correct copy of the website found at iTunes. An attorney at my firm accessed the cited website and printed the attached exhibit. That's it. Okay, let's go to Kaufman's affirmation. Guys, I told you, I'm going to enjoy this. The formatting is probably wholly unprofessional. And I don't even care. Because I'm relatively sauced, and I'm reading through just endless ridiculousness. And I wasn't going to include the restraining order, but I am. I am, because I want this to hit 2 hours. So we're going to get there, y'all. I wasn't going to include it because I hadn't read the documents, and I didn't know that they doxed 80s Girl in the documents. So we're going to go on to the restraining order, because now that I've already doxed her and said her name like 100 times, I'm going to say her name some more, and I'm going to say Jessica Irene Blum over and over and over again. Joshua Kaufman, an attorney duly admitted to practice law in the state of New York, hereby affirms the following. I'm a defendant in the above captioned matter. I'm also general counsel and senior vice president of CMGRP, doing business as Weber Shandwick. I respectfully submit this affirmation in support. Okay, who cares? Weber Shandwick is a leading global communications and engagement firm. Always on that PR spin, Kaufman. You really are a corporate dude. Headquartered in New York City and with offices. Yeah, we get it. You're super important. I get it. Weber Shandwick is a leader in all key public relations practices and provides services in corporate issues and advocacy, advertising, market research, and visual communications. Attached here too as Exhibit 1 is a true and correct copy of an email exchange dated whatever. Let's go immediately. Let's go immediately to the email chain. Exhibit 1. Here we go. I'm going to read this and just pretend that either Metal Jessica Irene Blum, trade show model and failed intellectual, is writing this, or even funnier, that Maddox, self-proclaimed but factually deficient intellectual, is writing this. The person who believes they have expertise over every actual expert and demonstrates expertise in nothing, not even undergraduate degrees. And by the way, this isn't meant to denigrate any undergraduate person who failed to complete their degree, because people fail to complete their degree for all sorts of reasons, even if they're just bad test takers. But Maddox is a self-professed intellectual who fancies himself a relevant, serious talker on his podcast, on Best Debate. And at the end of Biggest Problem in the Universe, you could tell he thought himself anything other than a jester juggling with an anal plug for our amusement. This flipping, stupid internet comedian from 1997 who hadn't been relevant in almost a decade fancied himself someone we care about their intellectual credentials, of which there are none. There are none. Maddox, I'm going to say this as someone who I do not use my education in any way to gain an upper hand other than like the inherent benefits that being trained in the art of communication and argument confer. I do not use the fact that I have a doctorate degree to put myself above anyone else other than the inherent benefits of having a doctorate degree, right? And I acknowledge that there are doctorate degrees, PhDs, which are probably superior to mine. Absolutely. So I don't do this on the basis of my degree. But as someone who was able to complete the basic task of undergraduate and then postgraduate education, you are an intellectual lightweight of the finest order. You have barely thought out, non-logically connected, unreasonable deductions or induction. Make very little sense and are only meritorious in their comedic value. And the moment that veneer was dispelled by your obvious idiocy, by your obvious, blatant, patent, on its face idiocy, the moment that veneer was dispelled, we suddenly realized in that 1 second that you actually thought you were smart rather than funny. And it was the funniest thing we could possibly entertain. It was the funniest thing on earth that you thought that the funny line that you don't eat apples from the top because you're not a fucking horse was actually smart. Like the moment that you thought that was smart and not just funny was simultaneously liberating, exhilarating, and depressing for those of us who have held you as fans for a long time. Dear Lord. Is the stream? Hold on, guys. Tell me if the stream is coming up. I'm gonna drop a comment because I'm getting indications that there's lag. How's the audio? Okay. All right. In case that didn't come through, I'm going to go through it again because I'm going to go through it again. Did the audio work or was it just a video? Okay. I'm going to go back to that rant. I'm going to revisit it because basically, the moment the veneer of Maddox's intellectuality was dispelled, was simultaneously exhilarating, frustrating, and depressing for all of us. It really was. Because we thought that you were just funny, making funny observations, and we didn't think that you actually thought that you were smart. We thought that you realized that your observations were comedic, ironic, incidental, all of those things. We thought that you were in on the joke of your own intellectualism. I don't even know what the word is. I don't even know. We thought you were in on the joke, but you weren't. You're just a pseudo-intellectual masquerading on the internet as some sort of titan of mind. And it turns out that you're just a dummy. You're just a dummy who was making comedy by happenstance. By chance, you were being funny while you thought you were being smart. And that it's like when a kid is building a Lego castle, thinking that the Lego castle matters in some grand scheme and that it won't be destroyed tomorrow by their younger siblings. And I apologize for couching everything in the frame of children, but I have multiple, right? So that's the reference I have. It's like watching an actor espouse a political opinion and expecting it to have merit because they played a politician in a movie. That's you, Maddox. You are like, you are Alec Baldwin. You're Alec Baldwin in Team America. Right, you fag? The Film Actors Guild fag, the acronym, not the derogatory homosexual terminology. And not a bundle of sticks, right? I'm talking about specifically in Team America, the Film Actors Guild fag. That's you, Maddox. You're a fag in the Film Actors Guild from Team America. Just like Alec Baldwin. Assuming that because he played some sort of political activist in a movie that his opinion had merit in some sort of way. You Film Actors Guild fag. That's you, masquerading as someone important while just being a jester juggling for us on the internet. Okay, I think I have sufficiently ranted about the Film Actors Guild fag that is Maddox. And I'm going to say Film Actors Guild fag over and over because I'm not referring to the derogatory term for homosexuals. I'm calling Maddox a fag in Film Actors Guild because we know that Maddox appeared as an extra on a film, right? And he also appeared as a host of a game show that no one ever watched. So he is presumably, and he would be in the equivalent reality, the Screen Actors Guild, he would probably be in a unionized contract under the Screen Actors Guild. So I'm going to call him fag over and over. Again, not meaning any denigration towards any homosexuals. And by the way, if you are homosexual, you need to register with the top gay, Tanner Gregory, because his office is looking to accept you. And we're all looking to accept you in the long run, right? But Maddox, you fag from the Film Actors Guild, who fancies himself anything other than a fag, but an intellectual. That's you, from the Film Actors Guild. Again, I'm being very specific, that I am not denigrating or disparaging homosexuals. I have nothing against them. I'm merely referencing a popular movie title with the Film Actors Guild, of which Maddox is comparable to those actors. So, let's be clear on that. Now, I have ranted enough for long enough. Let's get on to this email, and then we're going to go into the flipping order for protection, harassment restraining order, whatever it's called in California. Thank you for indulging me in all of this. Dear Josh, this is from Heather, aka either Maddox or Jessica Irene Blum. Thank you for getting back to me. Here are a few considerations, you pretentious pile of garbage. Let me give you some considerations. You executive of a multi-billion dollar multinational firm, and I am a nobody from California. We are approaching this differently because several of our journalists have received credible threats. By the way, this is not how journalists act. They don't approach things differently. They have journalistic standards that they follow because those journalistic standards lend credibility to the journalism that is produced as a result of those standards. There's an Associated Press writing guide, that they follow to make sure that all of the agreed upon publications with any credibility, and you could find this out with a modicum of research, by the way. Any research, you could probably find a WikiHow on it, you inferior human being. If you do just a modicum of research, you'd find out that there are journalistic standards, which pretty much any respectable journalistic publication adheres to lend themselves credibility, even when they're being incredible, right? Even when they're being incredible. They don't do things differently out of some sort of fake threats. Anyway, sorry, again, a digression. Several of our journalists have received credible threats. Have they? Have they now? This would be news stories, by the way. Journalists receiving credible threats are news stories because they're usually in response to an existing news story, and that bolsters their claim, you flipping idiot. Private information leaks and harassment. You know this is true. You know that this would be covered because Gamergate was covered when, quote, credible threats cropped up. When doxing happened, that stuff was actually covered by Gamergate. So there would be there would be something out there to support this bald allegation. We're trying to protect the identity of those involved, including myself. Journalists don't protect their identities because in just a minute, they're going to put their name as the author on a publicly available piece of press. Why would a journalist ever protect their name? They're protected almost entirely by the Constitution. Journalists can lie about public figures to the point of defaming them almost intentionally because of the freedom of the press. And by the way, we live in the most oppressive, and think about what this means. We live in the most oppressive era of the press, maybe in history, because back when Lincoln was elected, and by the way, Lincoln's campaign was funded by one newspaper, something like 80% of his campaign. One newspaper. That's what media bias actually is. Media has been biased from the inception of our country. And media has been propagandized from the inception of our country. That's why you don't ever rely on one stupid source. But anyways, journalists attach their names to things all the time because they have penultimate protection under the Constitution, probably more than a preacher at the pulpit. You stupid idiot. And you know who knows this? Weber flipping Shandwick, the public relations firm who protects media organizations as a matter of business. You never out-con a con man. Go watch Digstown and listen to James Woods, you bald pile of crap. Sorry. We are interested in seeing if companies who support these individuals financially will hold them accountable. What does holding them accountable mean? Maybe you should let them know what you expect them to do, you stupid, stupid, stupid Armenian. This is not meant to denigrate Armenians at any time. Many Armenians in our society are successful people, like Anita Sarkeesian, despite any merit to her success, and the Kardashian family, again, despite very little merit to their success. Although I will say, and I'm going to digress again, because I'm in rant mode now, and you signed up for this. I apologize. Anyone who can take their name and turn it into a $100 million plus franchise, they're not the idiot that they're called. The Kardashians, I have actually nothing but respect for turning that booty into $100 million enterprise. I have nothing but respect for, like Paris Hilton, for turning her name into a multi-$100 million enterprise. And anyone who thinks these people are stupid, are really underselling what they've done in a business sense. They've accomplished more than most of us. And granted, they had a head start, but they properly managed that head start. Something that Maddox, let me remind you, someone with hundreds of thousands of unique visitors to his website for 2 decades has failed to properly capitalize on. So someone with a proper head start by being one of the first internet satirists to have notoriety and have hundreds of thousands of fans, hundreds of thousands of YouTube subscribers, has not made himself a millionaire, but has made himself a laughable roommate in LA, right? This is his level of ability. His level of demonstrated ability is to be a roommate in Los Angeles. Whereas Paris Hilton has turned her name into a multi-hundred million dollar brand. So have the Kardashians. For all of the fun we can make of them for everything, they're actually rather shrewd business people. Or they hire shrewd business people, which is what a shrewd business person does, by the way. You hire someone to compensate for your lack of expertise. Maddox. Hire someone to compensate for your lack of expertise in marketing, in law, in comedy, in podcasting, in brand management, in everything that you have done in the past 3 years. Rant over. Rant over. I'm going back. Sorry. Thank you for the information about AT&T. They are a brand that has worked with Sirius in the past. We are reaching out to companies who support these individuals financially, and AT&T or its subsidiaries has contracted work with CMG IGC. Apologies if Weber Shandwick was not directly involved. Because they're a subsidiary corporation, so maybe they had nothing to do with it, you flipping idiot. If you would be willing to provide a current list of campaigns and companies that Sirius has worked with, we'd love to reach out to them for comment, because they're going to do this. Because we're going to do this. If you're unwilling to give a statement due to the relative anonymity of this piece, what journalistic piece has anonymity? That's counterthetical to the whole purpose of journalism. You're trying to expose something. So why would you have anonymity, you dumb moron? I am not just a journalist, but an activist. And what activist has anonymity? An activist who's a coward. An activist with any sort of testicular fortitude is going to not have anonymity, because the whole point, and again, I'm going to rant again, and I'm going to talk about this in a future video on my channel, but when we have a generation of people who think they can have activism without consequences, and by the way, Maddox, in case you're listening, you have a shirt that says civil disobedience is still disobedience, and yes, that's apt. The funny thing is, you probably got there by mistake. But that disobedience and the punishment thereof is what makes civil activism meaningful. The fact that in the time of Gandhi, that Indian people would line up to be beaten by police, and that when they would get struck on the head would go back to the back of the line and come back again. The fact that the person, the police officer, having to swing his nightstick and hit the same person the second, the third, the fourth time while they're already bleeding from the previous strikes, that's what gave meaning and changed the minds of the person persecuting the weak. You idiot. Anonymity and activism are antithetical to each other. They're antithetical. Yes, you want to stop the government when the government might label you as terrorists from tracking your work. But when you're talking to the public as a member of the press and activist, the fact that your name is attached to it is the entire point, because you're willing to go to jail for your beliefs. And if you're not willing, you're a coward, you're a fake activist. And Maddox, you are a coward and fake activist on your comedy and on your pseudo-intellectualism and on your current seriousness. You're a coward. You're a fake. You're a fraud. You're a phony. And again, let me remind you, you're a failure. Rant off. Again, I apologize. I'm going out of this on this stuff. My goal is to see if companies will hold them accountable once they know about the illicit activities of their employees. Then why do you need to talk to the clients of the employers, right? To be clear, Sirius Kokonos works with a writer named Dax Herrera, who goes by the pseudonym Dick Masterson, of the website Men Are Better Than Women. Of the satirical website Men Are Better Than Women, pointing out the fallacious arguments of feminism. And there are myriad fallacious arguments associated with feminism. That's not even a controversial statement. I think many feminists, like you've got Christine Hoff Sommers, would agree with you. There are countless articles about rape on the website. Here are some quotes, and I'm going to read these quotes verbatim. And they may contain explicit material, and it is not mine. I would never utter obscenities on a public broadcast, right? Quote, a guy who fucks a drunk girl who passed out in his bed isn't a rapist. He's just a dick. Get over it. First of all, that's satire. Second of all, it might not actually be rape, because rape is a legal conclusion that has a whole lot of factors leading into it. And the nature of consent is not one so easily memed down into a non-considerable action or a non-considerable analysis of what actually happened. And the fact that this flipping happens in our society today is actually disgusting. And the fact that there are bootlicks out there supporting the state taking unfounded allegations of rape, or not even the state, but public perception taking unfounded allegations of rape and accepting them as gospel, is actually disgusting and antithetical to the founding of our country, which presumes innocence absent proof. Sorry. I am a freedom absolutist. I am a radical for freedom, and I will not apologize for it. I do not think women are responsible for being raped, but I actually support the conclusion of Dax Herrera, Dick Masterson, when he says that not that women are responsible for the rape, but they should expect it and prepare for it for their own safety, because everyone expects and prepares for things for their own safety. And that coward pile of garbage Maddox, stating that he brings a duplicate wallet like the giant idiot that he is to Central and South American countries, because he's also probably a racist against Latino culture, right? Stating that they're going to steal his wallet, so he must bring a duplicate. That is the exact same argument. You're protecting yourself from an expected outcome, not justifying that outcome, you stupid coward. Sorry. Quote, all date rape victims and drug rape victims are lying whores. Again, this is an obvious satirical quote taken outside of context from an obviously satirical website that I believe states its own satire. But if you don't get it, you don't understand satire. And Maddox, as a self-proclaimed satirist, you putting this out there is disingenuous, makes you a liar. We all know it, but just so you know. Sorry. Quote, being the victim of date rape is like being a victim of getting a flat tire when you drive off a cliff. You did it. It's your fault. You're lying about how it happened. Again, this is from a satire website, from a comedy book. Quote, if women really hate rape so much, then why is the first argument they always haphazardly spit out of their mouths? Without women, none of you men would even be here. Without rape, none of you twits would be here either. This is obviously comedy. Okay. Women are whores, they know they're whores, and sexual harassment lawsuits are the proof. Getting hit on or having your ass grabbed is not a big deal. And you know what? There's actually an argument to be made that getting hit on is not a big deal. People should obviously not be touched without their consent, because that is the tort of battery. But getting hit on, no one has a right to not be hit on or to be hit on. Please don't hit on me, because I'm not interested. I'm happily married. Even if you're reluctant to give a statement, I implore you to Google Asterios Kokkinos and Dick Masterson to see what your employee is up to. By the way, imploring someone to Google someone to find out what they're up to is not actually requesting an investigation. So you didn't actually establish through this email a duty of care, you flipping dummy. You should be aware of the misogynistic nature of who you're employing. Why? Why should they be aware of that? What possible influence does that have on their ability to do a job? None. 5 minutes of Googling will yield this information. How can you quantify that it's 5 minutes? Maybe it's 30 seconds. Maybe it's 20 minutes. I don't know. Maybe they're proficient at Google. Have you considered that? Have you considered anything? Okay. Thank you for following up. Heather S. And then note the flipping pathetic errors in their own thing. Whatever. So mind you, and mind you, the sheer lunacy of someone from Condé Nast emailing from a Gmail website rather than a Condé Nast domain name. Like, why on earth wouldn't they have an employer-related domain name? Next email from Kaufman. Dear Heather, as stated in my original email, we take these matters very seriously. Of course they do. They're a public relations firm. Of course they take the matter seriously. I'd be happy to set up a time to speak with you. Oh my gosh, some guy that makes 15 times what you make is willing to set up a meeting with you for free? This is a lawyer willing to speak to you for free. Try and find that guy outside of this context. The number you've provided below goes to the Condé Nast switchboard, and there's no way to reach you with just a first name and last initial. Probably because there isn't even a Heather. Well, I mean, I'm sure there's a Heather at Condé Nast somewhere, right? They're statistically likely. As a professional journalist, this is a good jab. I'm sure you understand that we need to verify. I am monitoring the chat, Age Jesus, as best I can, but my attention is being focused as my liver processes this alcohol. It's being focused in one place, but I'm looking for jokes, so please feel free to go on. And I'll drop them as they come up if I'm looking at it, or not if I'm looking at it, but if my brain recognizes it. As a professional journalist, I'm sure you understand that we need to verify the identity of any reporter we speak with on the record. Obviously, if you were a professional journalist, you would know this. What's up, Meat Goblet? I also wanted to let you know that contrary to what you wrote in our original email, AT&T is not an active or former client of ours. So your basic information and research was wrong. Wow. Paul not walking. That's the wrong use of there. You should probably consider writing complaints for Maddox due to your lack of apostrophe. Let's see. Heather then responds. And Grimpify, whether it's Jesse PS or not, like, let me let you in on a secret. And I'm going to publicly state this just in case. I don't actually care about Jesse PS. I'm sad that he's attacking my business for no real reason. I'm sad that he made the decisions he made because I think actually his comedy would have jived well with Dick's fan base, and he probably could have boosted his Patreon and actually synergized with Dick, but he chose not to. So I'm stating this against my policy because I've been drinking. I tend to not interact with him in any sort of way, despite the fact that he is taking a picture well out of context, misrepresenting what the picture is, either based on willful ignorance or just basic ignorance, and trying to disparage me in a small town law practice that honestly, like, I don't think most of my clients come to me through Google. So the fact that you spent your time SEOing it to the top result on Google, like, I commend you. I commend you for doing that. And how you did it is pretty cool. I should probably take an SEO class from you, or you should sell SEO business to other people. You're good at it. But here's the thing. Like, I don't think it really damages my business. Plus, I'm actually a free speech absolutist. So I did not show up in blackface, despite your allegation. I was dressed as a specific person at a private event, and the picture was never meant to be public. I'm not making a commentary on any sort of culture through my costume. I'm literally making a commentary on the person. By the way, some of the articles of clothing I'm wearing are actually his, because he's a close personal friend of mine. He thought the joke was hilarious. So did everyone at the private party. So you're taking something well out of context from 10 years ago. And trying to paint me in a bad light. And you're trying to assert in some way, even though, despite all evidence, that I somehow deny or am ashamed of this action. I'm not ashamed of that picture in any sort of way. That is a picture that I took, and I'm happy that it was taken because, we all got a good laugh out of it, including the target of the joke, who was present. And that's a fine thing, because speech is actually free, and we can actually go ahead. We can actually say things that offend people and bother people, especially people who are wrong about the context of it. And that's okay. So, if that sinks my chances of being president, if that picture from, Halloween, I think 2005 or 2006, whenever it was, sinks my chances of holding office because you hold a personal vendetta. And let's be clear on why you hold this vendetta. I called you unfunny on the internet. That's it. On a private group that you chose to come to, I called you unfunny. And I would call you unfunny again because I didn't find you funny. It was factual. But you're also on a trolling site, and I was trolling you. So anyway, if you're watching this, man, I don't care. I don't care about you. I'm not interested in a feud with you, which is why I haven't addressed any of this stuff. You're going after someone who has less of an audience than you, and your audience is pitiable in the grand scheme of things. So if you're posting this stuff, I mean, I guess try and defame me based on out of context things or misunderstood things and demonstrate your own ignorance. You're okay. I'm okay with that. There you go. I'm obviously going to oppose it, by the way, before you try and call me out on some sort of hypocrisy. I'm obviously going to oppose it because I have a business interest to keep up. So I'm going to oppose it. But if that opposition fails, okay. I'm okay with that. Yeah. Again, I'm a free speech absolutist. My job literally entails defending people's speech. I would defend your speech if you were in my forum and you hired me, no matter what you said, because I support all speech, even the most offensive, vile, degenerate, disgusting speech you can imagine from whatever perspective you take. I'm a freedom absolutist. It's part of why I'm a lawyer. The fact that you're trying to call me out on hypocrisy is laughable. Okay, sorry. Sorry. Okay, anyway. Yeah. Back to this. And again, I apologize for the digression, but you guys signed up for a live show. This is on you. Dear Joshua, this is from Heather again. Thank you for getting back to me. I'm on assignment in London until the 9th. This is obviously a lie. And can set something up when I return. Until then, I'd be happy to take a statement. Again, you don't provide your credentials, so how is he able to set up anything? Be happy to take a statement with regards to online bullying and harassment if you're able to provide any. I'm gonna take a statement from you without anything. Dear Heather, I'm general counsel for Constituency Management Group, which includes Weber Shandwick. Your email was forwarded to me. Again, this is Kaufman. We take these matters very seriously. If you provide me with your complete contact details, I would be happy to speak with you. Again, basic things. And then here's Heather again. And then notice, if you notice up at the top, you've got a bunch of people presumably Weber Shandwick executives that she's emailed, as they stated in the complaint. Dear Weber Shandwick staff and AT&T. They actually sent to AT&T despite Kaufman saying that AT&T is not a client of Weber Shandwick. Can you imagine the temerity of this? CCing AT&T on this because you've worked with Weber Shandwick for online print before, despite Kaufman. Like, right, where was it? AT&T is not an active or former client of ours. So he told you they're not a client, and then you went ahead and said they were. Jesus. Where am I? Sorry, I lost it. My name is Heather. I'm a freelance journalist. Now you're freelance, writing on behalf of the Condé Nast Media Group. So you're not associated with Condé Nast. Oh, am I reading these in reverse order? Oh, good job. Put hat on head and show sash. I got it. I gotcha. We can do it. We're late in the stream. Anybody still watching? I'm with you. Let's see. Whoops. What's the top here? All right. Road Rage Champ. Here we go. Okay. All right, you're right. I'm reading these backwards. So we know they don't say anything useful. Maybe I should drink less while doing this. Probably not. Let's get to... I was going to not do the restraining order until I found out that the restraining order was actually shown, or that the doxing occurs earlier. So here it is. Here's the restraining order. This is the petition. So this is a form document you file on generally like a pro se basis. This form document is for a civil harassment restraining order after hearing. So they're going to go in, they're going to allege the harassment that has occurred, the damage that has occurred, and why they expect the damage to continue. And so why they're asking for the court to intervene and say that you can't do it. Let's see. The lawyer for the person is Keon. Good job, Keon. Honestly, hashtag respect for stepping up and doing this. They needed the help on this, and yeah, absolutely ridiculous that they had to do this, and I'm glad you did that. You're a good dude. Harass, intimidate. So the alleged action is harass, intimidate, molest, attack, stalk, threaten, assault, hit, abuse, destroy personal property of or disturb the peace of the person, contact the person either directly or indirectly, including but not limited to in person, by telephone, in writing, by public or private email, interoffice email, by email, text message, fax, or other electronic means, and then take any action to obtain the person's address or location. If this item is not checked, the court has found good cause not to make this order. Stay away orders. Stay 100 yards away. 100 yards. A football field away. Good job. A Usain Bolt 9 seconds away. The person... Okay, I'm not going to go through this. This isn't the juicy, salacious stuff. Let's go ahead and get to that right now. So they go ahead and redact Jessica Irene Blum's name from this document, even though they keep Maria Valenzuela's name, which is almost sad, because Maria Valenzuela is the one who is deemed by the court to need protection, and she's the one who should be protected in this case. She's the one who should be protected. Her name should be blocked out. I'm going to call a mild foul on Weber Shandwick, although, at some point they have to disclose this stuff. But they should not have protected Jessica Blum's information, despite her being labeled as Jane Doe, because they know that's bogus. So I'm going to say it. Jessica Irene Blum is the party with a restraining order for court-verified harassment against a person who is not involved in this at all. Which means she's an absolute dirtbag. Okay, description of harassment. When did it happen? May 4th, 2017. Who else was there? The office manager, Nancy Rojas, and a fellow employee, Elijah Sugar Ray. Jessica Irene Blum called Valor Academy Charter Middle School, where I teach, and filed a fraudulent harassment or HR complaint. Sorry, I'm inferring there. A fraudulent HR complaint claiming I shouldn't be around children, which is just a disgusting accusation. Because, by the way, if you're not in the legal world and you don't know, people who are alleged to not be around children are typically child molesters or child abusers and no one else. So simply saying that they shouldn't be around children leads to a specter or an inference that they are abusive or dangerous to the health and welfare of children because they made fun of a balding, washed-up comic who isn't funny and isn't important. And actually they didn't, because their boyfriend did. That's how disgusting this complaint is, and I hate this stuff. I actually just defended a client against a false harassment restraining order in which a person alleged that they beat them with belts. Okay? And it was all a lie, and it's just revolting to see this nonsense because it is permanently damaging to the reputation and even hireability of the person. This Jessica Irene Blum should be in jail for this, probably for a felony, if you asked me, because lying about what someone does to children is disgusting and should be fired, which initiated a meeting with administration, which was recorded on my permanent file. Jessica Blum then called Valor Elementary School in my charter's network, claiming the same, because she was too stupid to even know which school she worked at. Jessica Irene Blum has been threatening to do this for months, and it has caused me sleepless nights, migraines, missed work, vomiting, and stress-related injuries. That's really unfortunate. I can't, as a lawyer, we get some inside track on people's lives through these processes, and I said it at the live show in Chicago, and I can't say it enough. This is honestly, this type of stuff is the worst time in many people's lives because the stress and the cost and the risk is more than most people they didn't sign up for this, right? They didn't sign up for anything. They're just being accused of something that in this case especially she didn't do. And it's threatening her career, her reputation, her future profession in any sort of capacity, her public perception, all of this, because this is all public record. This is going to affect how her family looks at her. Anyway, just pisses me off. Jessica Irene Blum has created a fake and sexually explicit profiles of me on Twitter with my school's information. How disgusting is that? And encouraging people to contact them. Absolutely revolting. She's emailed me and my boyfriend with threats to contact the school where I work, the administration, and the parents of the students to inform them of the said profiles. They've contacted my boyfriend, who is a celebrity, with similar threats unless he complies to her requests. Basic bitch blackmail. Other active. So they've harassed and contacted. Other activity: contact my place of employment or any future place of employment. Contact my family members and loved ones. Again, just disgusting. I asked the court that they keep 100 yards away from me, 1,000 feet away from the school where I work. Stay away from my home, my job, my workplace, my vehicle. Okay, Jessica Irene Blum is increasing her level of harassment by calling multiple schools and aggressively trying to get me wrongfully terminated. I'm living in constant fear of what she will do next and what she is capable of. And this is actual articulable fear, not the fake fear from Maddox, right? Where people aren't actually going after anything that matters to them. They're making fun of them on Twitter and Facebook. Jesus. I'm also worried for the safety of the children that I teach as well as their families. And you should be. You should be. Because as far as we know, Jessica Irene Blum might injure children for the sole purpose of pinning it on 80s Girl. And that's disgusting as well. We honestly, the lack of stability in this person's mental process is enough to infer that that might be a conclusion. I'm not going to go through these. Okay. Well, maybe I will. No, I'm going to, because we're still trucking. This letter serves to verify that on Thursday, May 4th, Valor Academy Middle School at Bright Star School received a call from a person named Jessica. Here's what follows. Jessica said that she is not a parent of the student at the school. Immediately disregard. I'm done. You can read it if you want. Gmail. This is to Dick, okay? This is to Dick from Jessica. Maria Valenzuela, not Venezuela. She's not a communist. Maria Valenzuela from the Valor Academy Middle School will be receiving a call on Friday if Dick and Maddox don't apologize to each other and end this shit. Think about what this person just did. Everything that Maddox alleged, threats, like a quid pro quo blackmail style threat, that's what Maddox's girlfriend just did. Friday will be a simple call to show you I'm not fucking around. The following Friday, I send a bulk email with every bit of information I have on you and George to the entire school directory. A blatant threat of actual damages. This, again. After that, I move on to everyone's families. What does that even mean? Does that mean emails? Does that mean physical violence? Does that mean harassment? We don't actually know. I presume the worst in these sorts of situations because this is an actual credible threat from someone. This is an attempt by me. Like, credible threats. When you know someone personally or can identify them through association, like maybe secondhand, that's when threats become credible. Anonymous people on the internet, probably not a credible threat, right? Like saying get raped to someone, probably not a credible threat. But a secondhand person who knows either you or who knows someone that you know intimately, not to imply that Dick and Maddox know each other intimately, although Maddox did cry in front of Dick, so maybe they do. But that becomes, that tips the scale of credibility. So just so you're wondering if they, how they kind of determine that stuff, that's one of the ways. This is an attempt by me to get everybody to back down for their own benefit. Hey, why don't you work on your boyfriend, cuck Maddox? Like, while you're out cucking him and he's sitting there watching you be with other men or whatever it is that you guys do, that's just my opinion, not a factual claim. Why don't you moan to him the exact nature of what you want, because he'll probably do it, because he's followed lockstep with you in becoming an abject pile of pathetic since you two started dating. It was observable in real time. Oh, I dropped the sash. It was observable in real time, so you could just tell him what you want him to stop doing and he'd do it. And by the way, Dick stops when you guys stop, which is obvious. I know neither of you want this to go further. Seems Maddox wants it to go further, considering he filed multiple lawsuits. I love both shows. Do you? Really? And want the content to continue. And we've got an IRC chat. That's all I really want to go through. Aside from Metal Jess calling 80s girl a fat-ass teacher who can't keep her legs closed. Again... Like, I met 80s girl in Chicago, and she is literally anything but. She's actually quite beautiful, very thin. Not that I need to defend her or anything, but she, seems like a genuinely decent person, unlike most of us, right? She doesn't deserve any of this, as far as I could tell. I don't know. Maybe she's terrible in her free time. Whatever. She seemed wholly charming when I met her. Do you want me to go through the IRC logs? Do you want me to go through the IRC logs? And no, I'm not white knighting. Just going through my experience. Although I know you're talking about a joke. Do you want me to go through the IRC logs? Someone answer me quick. I can. Okay. I've got yes and nah, but mostly yes. No skip IRC. But mostly yes. Let's do it quick. Okay. Hello. Okay, advertisement. Hey, can you please pass a message on... Like, this is apparently redacted, but I can read it. So we're going to read the redacted stuff because that seems more fun. Hey, can you please pass a message on to Dick for me? Nope. PM me, hun. Confirmed. This guy is a Maddox about to admit defeat. Okay, but I think it's important. I have access to all the information about his girlfriend and her job. Okay, so this must be Jess. 0, no, it's over. But Woods, they won the war, remember? I am ready to start sending all details to the school and parents if Dick doesn't call it off. So again, here they are, making threats in a way that is tangibly linked back to them. I'm not going to take my shirt off, buddy. You know, it's best left to the imagination. But I will show you my shirt. It says old school, has an old Atari controller on it. My kids have new school because dad jokes are funny, and they have like Xbox controllers on theirs. Kyle Belmont, remember the good old days when we would talk about stuff in places and places in this channel? Then they say email him, right? Like, talk to him. Take your shit elsewhere. IRC isn't the place for it. Doesn't have to be big thing. Just needs to tell everyone to pull their head in. Because what you failed to understand this entire time is that Dick has nothing to do with the actions of his fans. And then they got kicked out. I said, fuck off, email him. Good job. Who knew the IRC was funny? Hey, tell Dick I'm threatening him. Good job. Okay, so here we go. They go back. She comes back in and then says, bitch is a 5th grade school teacher. I'm not bluffing, you know, talking about 80s girl. Whatever, no one cares. Threats of doxing have no power here. So the IRC wasn't really, you know, complicit in any of this. So we have the Superior Court of Los Angeles, nature of proceedings, matters called for hearing. Let's see, is this an order? Temporary restraining order. Okay. Relationship to protect a person. She's dating someone I used to be in a relationship with. You know, this is all just basically the court is granting the order. Like an 80s girl was allowed to basically write her own ticket on what the order should be. And that's because the actions of the defendant were so flipping egregious. They were so egregious that the judge just let her go ahead and write whatever she wanted. And her request was reasonable, you know, like, leave me alone, stay 100 yards away from me, stay 1,000 feet from the schools where I work. Absolutely fine. So, you know, that's the hot goss here, guys. Metal Jess is even more of a piece of shit than we knew. Maddox is a pile of garbage. You know, Weber Shandwick's motion is devastating. It's absolutely devastating. You're not supposed to be overly argumentative in your motions, and they outside of presenting a logical argument, right? You're not supposed to be petty, funny, witty, and they were petty, funny, and witty to the extent that they're allowed to be in great fashion. They absolutely obliterate the article or the arguments that Maddox puts forward. They basically point out that Jess is Jane Doe, who is also Heather, which is huge. And the best part is they found a way. They, who have nothing to do with the restraining order, went ahead and found a way to incorporate the restraining order in a matter that damages Maddox and Metal Jess. So, Jessica Blum. So anyway, thank you guys for watching me. I didn't think by any chance, Jessica Irene Blum, sorry Tess, thank you guys. I didn't think there'd be any way we'd have over 200 people watching. That is fantastic. I'm going to have more of these. Although Although I will, I promised $10 plus Patreonies access to live stream content. So public live stream content will be limited because I have to fulfill an obligation to the people who have supported me monetarily. I will do public live stream content from time to time, but I'm actually looking at setting up a weekly live stream or live chat that will happen probably around 2 p.m. on Wednesdays, Central Time. If you're interested in joining that, if you're interested in a live chat or live stream, we're going to talk about all sorts of legal stuff. We'll talk about goss. We'll talk about, we'll answer legal questions, just for free and for fun in the context that I'm able to without providing legal advice to your specific thing, but just giving you general legal principles or clearing up questions. That's all going to happen starting very soon, probably weekly or bi-weekly. Check it out on Patreon. Or message me on, no, not 2 a.m. Tess. This will be at 2 p.m. during the work days. And it will be from my actual office, not my home office. I'm working on alternative audio setup there. So, please join me. But do it through Patreon. I appreciate all of the support, all the views, all the comments. I love interacting with you guys. The only sad thing about this live chat is that I'm not able to follow the chat as much as I would like to. So again, thank you all. Lots more to come. If these idiots would stop filing documents in this lawsuit case and stop filing in the trademark case, we're going to cover James Damore versus Google, and we're going to cover Creep versus Radiohead versus Lana Del Rey over her potential infringement of Creep. That will probably be one video, but the Damore versus Google is going to be a long series, I'm guessing. So anyway, stay tuned. Thanks. Love you all. You know what I mean. I'm going to go ahead and end the stream now. I don't know how you end these things. And I'm absolutely going to use Rekieta Law Service to host every harassment campaign possible. And no, this is not Kruger. This is Indiana Jones, buddy. Indiana Jones. I'm a 1940s Nazi fighting archaeologist who is also a professor. So Grimpify. Radiohead is suing Lana Del Rey over a new song that sounds shockingly similar to Creep. So we'll be covering that and what it looks like to try and sue for copyright infringement on a chord progression or a set of notes. So if you're interested, again, stay tuned, subscribe to me on YouTube, share me with your friends. Even if they're not fans of the Dick Show, we've got a lot of non-Dick Show content coming. And, yeah, Vistus, voicemail you. Who's Vistus? Anyway, I'm gonna end the live stream, and I'll continue to be in chat for a few minutes. So, thank you guys. I'll keep this up, forever because that's how we do it. And no edits. So later.